Joanne.
Everybody.
How can I mute the meeting room until we actually get started?
Right.
That's right, back to dirt.
I see it.
Because there's no base.
Yeah, because once,
There,
anytime you want to.
yeah, it's important
over there.
build the acres out right now.
I mean,
on the Jack.
But right now it is
That's the time that
it is
warehouse
unmuted.
wants, 'cause
They're
no one else
changing their
cares because there's no one else in the meeting.
Right, so now.
Because I haven't let anybody else
plans
in,
on the
right?
truck, but Meanwhile.
So if so what you're saying is, I
Point.
can't use
Yeah,
that stuff. I
But
do over
it's-
there. If I
there's-
need
You
to.
do, yeah.
Okay.
Well, it would be a combination. You basically need to request that this person unmute
Not,
and
I mean.
then that you don't need to actually unmute.
Nothing, but the good news,
Okay, but when I'm ready to get going and I wanna unmute us here,
think our log,
That one.
camp,
That one,
pictures
then
and
that one.
everything else.
okay. but-
Because it takes two keys to unmute, kind
Keys.
So-
of speak. You initiate the
So we
unmute
there
and then
yet,
that
there's
completes the
still
unmute.
hope. here.
Got it, okay.
I haven't had a below
Um,
0
And
day
then
yet.
when,
Last
and it's
year I
already
had
recording
29
and then
days.
the,
This
do I
year
stop the
yet to be
recording
below
before I
0.
leave the meeting? Is that how it goes?
You end the meeting and then the recording
Okay,
will convert.
It's just a matter of don't just shut my computer to
Yeah.
make sure to end it. That's the
That's-
kicker there.
That's one, to make sure to end the
Got it.
meeting, not leave the meeting.
No, they
and,
definitely not.
Okay.
It will start converting the file.
Okay. So, When we're ready to get going, I'm going to unmute.
Sear Cove, it's called.
Yeah.
Yeah, you click the unmute on there.
on me because
You just
the
go
meeting room is not muted right now.
around in your
We don't want them out there on. Why are you saying? Don't wait. I don't. Oh, I don't think so.
Admit everyone will let us know whether we are not audible.
Right.
6 months.
We're just trying to figure out if it's, is this a fight?
No, I've got boys,
Is there
so it's
another
like-
way to kind of underhand that?
Progress.
I have 3 sons and
I don't want to know this. It's not really. Never mind.
Between them, so it's like.
Trail
All right, I muted them and we have to
You're
give them a
also.
second to the background voice down. I hope that will.
No,
Steve,
no.
all right, it's up to you there, chief.
All right, Let's- it's time to call this meeting to order. So we'll call to order the January 11th, 2023 Abandoned and Discontinued Roads Commission meeting. Belated Happy New Year to one and all, and glad to see everyone here today. So with that, we'll call the roll, take our attendance for who's here today.
Good afternoon, everyone. I'll go by seat number for our assignments to the commission. Chris McCabe,
present.
Brian Bronson,
Present.
Pete Coughlin.
Here.
I am here, Vivian McHale, Rebecca Graham. Present. Carla Black. Here. Jim Katsifikas.
Here,
Steve Young. I don't think that Steve is on. If I have it wrong, I'm sure he will let us know. Ryan Pelletier,
Here.
John Monk,
here.
Roberta Manser, and Kathy Neto.
Yeah.
That is everyone.
Very good. Let me see, the first item of business is to adopt meeting minutes for our December 14th meeting. Vivian put together a draft. Has everyone taken a look at those? Any things that need to be corrected? All right. With that, is there a motion to adopt the minutes? So moved.
Second.
All in favor? And we'll have to do a roll call vote because we are doing a hybrid meeting with both online and present. So we'll go through the roll.
Chris.
Yes.
Brian,
Yes.
Pete,
Yes.
I vote yes. Rebecca.
Yes.
Carla. Yes. Jim.
Yes.
Steve is absent. Ryan,
Yes.
John,
Yes.
Roberta, Kathy.
All right, our minutes are adopted. Next topic on our agenda is the commission's online presence, which is an ongoing issue, and we're trying to remedy that. Vivian, you have something to report, and then I can just say what I've done, and it's about all I can say at this point.
Right, I feel like a broken record. We are, Jim will explain what we're waiting to hear back from OIT. We have our YouTube channel, but I'm still having a really hard time figuring out a way to optimize that so that people will actually find the channel. And I'm just without support staff to sort of get that all fired up, but one thing I can sort of a spin off of that is we are maybe getting closer to hiring for the paralegal position. We did extend the offer to one person and it didn't go anywhere because they needed to take something else based on the parameters of the position and what it could offer. So we have another offer outstanding. I hope to be able to report back that the position is filled. I did put in a notice for today's meeting on the main public community calendar, didn't make it on there. I'll have to check and see what that was about. And I did get, but probably not until too late, Rebecca's suggestion about getting on the legislative calendar. So we've got some options, obviously not ideal.
Mhm.
I'll hand
Right,
that
and
over to
we
Jim.
have been talking to the Office of Information Technology, dealing with someone who's a senior staffer there. But he himself is not able to actually do anything on this, but he has kicked it upstairs and we're just waiting to hear back. The idea is, can't we get on like other state agencies and commissions have their notices on a web page that'll direct you to a site on the legislature's website that will have all of this information, just like the right to know committee. It's analogous. It's set up by the legislature for just this purpose as a standing committee. We're waiting to hear back from OIT. As soon as we get confirmation that someone upstairs does or doesn't approve, then we'll go to the legislature and just talk to the legislators who wanted this commission started in the first place, because they would seem to be the likely suspects to come up with some funding. So that's where we're at. Less than satisfactory, and apologize for the slow pace of this, but it's going to move as fast as the people are making requests from. So that's where we are. Comments or thoughts or questions?
I would suggest that would be one of our key recommendations coming out of the commission, so that I believe that will empower that particular committee to have a bill printed to address them.
Roberta, you may be able to answer this better, but along that lines, you had people come in and speak. It was 15, 20. Do you have hundreds more, or do you have 50 key that kind of, if we could resolve those 50, would things simmer down?
Well, I have a map at home with a pin in each town that has a problem road that I've identified, and I have something like 265 pins. And some of those towns have multiple problem roads. They're not all current. Some of them are ones from way back where I found there was a lawsuit regarding a road in the town. Current ones, as I said, I've been getting about an average of one new complaint per week for the last year. So there's 50 current ones, and in the last couple of months since the commission has gotten going, they've been coming in faster. So
They're out there.
there's a bunch of them.
Now, I've got 5 or 6 ongoing litigation or administrative matters in my office right now involving roads, paper streets, abandoned ways. It's
I've noticed an influx from our side with them since when we started to get snow, the snowmobiles start going and people start calling about.
the
Like I was
ruts in
talking
their
to
road.
Roberta about it, and yeah, it just starts, and then it's a seasonal thing, but it's started already.
So it is ongoing. We're aware of it, and that's, I guess, why we exist as a standing committee. To come up with some ideas after hearing from folks. Which brings us to our next topic. Good segue. We received public comment at the hearing last time. We also received written comment from members of the public. What we're supposed to do is prioritize that and get back to the legislature with concepts of what the problems are and how the legislature might address that. We have 2 weeks to our next meeting, and we're supposed to adopt a report, and we have a report due February 1st. We are not going to have draft legislation ready in time for that time frame. We work diligently and quickly, but that's a little much. But what we can do is give a thought, as Rebecca suggested, talk about notice, but also talk about maybe the top few issues that we've seen from our public hearing, from the public comment. And some thoughts, initial thoughts anyway, if we can reach some consensus as to how those might be addressed.
One question I have, we gave town administrators a time limit to get in their testimony. Did we get any?
We did get a couple of pieces of testimony, or some thoughts from Rebecca. It's possible that those did not make it into the larger packet.
I hadn't seen those either.
Why don't we, let me look to see whether there are some things to share, but keep talking while I'm looking, I think probably makes sense.
Sure, and it might be helpful because many of us haven't seen those, and it's not a criticism if we haven't seen them. Would it make sense to hear from Rebecca as to comments that she might have wanted to forward to us?
I did, however, there are a couple of folks, I believe,
We're on.
on the Zoom who might give the actual voice to some of those comments.
Yeah, I have to apologize. I think they came in like right around the 30th, and I made a subfolder and then promptly in my organization didn't follow up and get all of that to you. Maybe I can make quick copies of that right now, but feel free to proceed if calling on people makes sense.
Would it make sense to hear from the municipal officials who submitted comments or who might be on now? So I think we need to get that input.
Is there a way you can share with us who is online, because we can't see it on this side of the room?
I see
Yeah, of
Mark
course.
Robinson, I believe he's the manager of KS, correct?
Unless there's two Mark Robinson.
Well, there is at least one other Mark Robinson I know of.
So the list is, there's a telephone number that I can identify, 370-4727. Code officer without a name, Don Ettinger, Mark Robinson, Thomas, is it Mar, and Tom Wheeler.
Those last two are not town officials as far as I know.
Does anyone who is online wish to speak? If there's some way you could let us know,
Maybe
is there a
they have-
raise hand function?
Vincent looks like he'd like to speak.
Mark, would you
Yep,
like to
just give me
speak to
one
us? If you could
moment.
raise your hand to say yes. Very good.
Good afternoon.
Oh,
Hang on a second, sorry about that.
We had you for a moment on vocals, but
And then it
not quite.
jumped.
Yeah, you only gave him a second. Right?
It was a turn of three.
I know, I didn't realize,
That's
done the
it.
thing.
Is that better?
That was completely my fault. I apologize,
Hear you
sir.
now.
Go ahead.
It's okay. Good afternoon. Thank you for this opportunity to speak. I do see a lot of familiar faces around the table. And I am forwarding on the recommended response to Rebecca's request from us on December 15th in preparation for today's hearing. Eventually, I assume all will receive a copy of this, so I'll just read the response. And it's in response to Rebecca's email of December 15th. With all due respect, the town of Fayette is assiduously following the current road laws and have no express desire to advocate changes to the current status. Young Road is a private road across which the public in general has a public easement. The town of Fayette has no obligation, statutory or otherwise, to maintain a private road, whether or not there is a public easement. The town of Fayette may, in its discretion, maintain private roads pursuant to 23 MRSA section 3105-A. However, the inhabitants of Fayette have not so authorized the use of public funds or public equipment to maintain Young Road. In the event emergency services are needed along Young Road, the town of Fayette is authorized to and will plow, maintain Young Road to provide necessary emergency services. In closing, the town of Fayette is fully complying with the laws on the books. It goes without saying that should the legislature change the current laws, the town of Fayette will comply with those changes when they are required to do so. That is the response from the Fayette Board of Selectmen, and I'm conveying that to you as their representative today.
Very good. Thank you.
Thank you.
Any any questions?
Can I comment on that?
No, sure.
Okay, I think this illustrates one of the problems that we've addressed, which is the confusion in terminology. A private road and a private way are not the same thing. Young Road is not a private road. It is a private way, which means that it's a public easement. And the town took us to court back in 1984 to prove that it was not a private road, that it is in fact a public easement.
Well, I think Mr. Robinson started the statement from the select board by noting that Young Road is a public easement or has a public easement.
They also referred to it as a private road, and this is where I said the terminology is tremendously confusing.
Thank you, Roberta. I would agree, if I may. My earlier rendition of this letter was reviewed by Mary Dennison. And Mary, in my earlier rendition, I had way, and she corrected me that the way should be changed to road. So rather than private way, it was changed to private road. So I appreciate Mary Dennison's correction.
Fair enough. Thank you.
Thank you.
All right. Is there anyone else on, who would like to speak on behalf of the municipal perspective? Is code officer who's on without video?
Not see any raised hands.
Okay. Well, if no one else would like to speak to the commission on these issues, then we'll continue our deliberations and
How many of them sent info?
I,
Just
thi- I,
two?
I think there's two, and I'm just about to forward you Mr. Robinson's, and then I also have something from Joy Downing from West Paris, which I will send to you. So tricky to.
Should be something from Diana.
They're doing
Myers, too,
some
maybe.
work on the floor below us.
Rebecca, do you remember that these all came through you? Did any of them come directly to the abandoned roads email?
They may have come through that way. I put it out as primary to send to that and then secondary to send to me, so. The ones that were sent to me, I had forwarded.
Okay, thanks.
It was an individual from Westport and then an individual from Ludlow.
All to the abandoned roads email?
No, those ones went to me.
Came from you. Yeah, I'm looking for anything from you.
While we're waiting, it occurs to me that maybe Mary Dennison's confusion is because she knows that I'm a member of the Maine Alliance for Road Associations, and she may assume that that means I live on a private road, but I don't. My daughter lives on a private road, and that's why I'm a member of NARA. So Young Road is a public easement on a private road. I'll have to speak to Mary about that.
Who's Mary?
She knows better.
Who is she?
Mary's an attorney. And does a fair amount of municipal law in central Maine.
And she also works closely with the Maine Alliance for Road Associations.
I see what's happening. So looks like a couple of things came in after the deadline and they did not make it into my folder. Do you want me to print this stuff out now, or just, I don't see how forwarding it is gonna help anybody at this moment?
Yeah, printing
Your
it out
preference?
now, how long is it?
Not long.
Okay, if that would at least we can look at it while we're doing our.
Yeah, why don't you keep going and I will print this out. It's a little. I'll print out these, if somebody else can maybe pinch it and take some notes until I give you the heads up that I'm back in my seat, that would be great. If somebody be willing to do that. Was that a yes, Rebecca? Awesome. Thank you so much.
Thank you.
Thank you, go ahead.
To open the discussion, we all heard the hearing, we have the minutes. We also have some of the discussions or summaries of who said what. Maybe it's good to go back and take a look at what we're supposed to be doing with all this information. Our duties are these. We're supposed to consider the following: property owner liability, including personal injury, property damage, and environmental damage liability resulting from public use of an abandoned or discontinued roads. Public easement retention over an abandoned or discontinued road, including the scope of permitted and actual public use, statutory terminology, related to abandoned or discontinued roads, and the statutory process for the abandoned or discontinuance of a road, including barriers to determine the legal status of a road. So those are considerations for the committee. For matters other than those described above, prioritize matters for consideration by the commission by determining which matters relating to abandoned and discontinued roads have a significant negative impact, qualitatively or quantitatively, on property owners of property that abuts an abandoned or discontinued road. Owners of property accessible only by traveling over an abandoned or discontinued road. Recreational users of an abandoned or discontinued road. Members of the public, municipal, county, or state governments, and the physical integrity of an abandoned or discontinued road and surrounding land. Then, with all that in mind, we develop recommendations on ways to address those matters, including recommendations for statutory changes, and we'll review legislation affecting abandoned or discontinued roads and provide information to the joint standing committees. Some bill titles have come out, but we're not in a position to be able to look at legislation for this session. What we can do, though, is talk about those matters that are within our jurisdiction that we've received comments on. So if we want to start with the duties section and talk about 1, 2, 3, and 4, property owner liability, public easement retention, statutory terminology, and statutory process, and then prioritize issues that we've heard that are outside of those topics. Does that make sense? Let's go down the list. So when we talk about property owner liability, personal injury, property damage, what if we heard that stood out in our consideration of that? Environmental damage liability. What are some concerns that we've heard that we think are worth acting on or at least considering?
I think one point you hit on at the end of the last meeting, you said that 2 of the biggest issues seem to be people who had no access because the road was discontinued without easement, and people who had a public easement and had no access because the public use was destroying the public easement.
That latter one would be property owner liability, property damage, environmental damage. With regard to that, I'd say it's A1 under duties. People with a public easement who, if they try to fix the road so they can use it because that's their only way to get there, wind up having the general public use it. And maybe snowmobiles, maybe ATVs or whatever. But if someone gets hurt, they can get sued because they did the liability. They have liability to the road. And is that a consideration, something that we think needs to be looked at, addressed somehow? We certainly heard about it from a few people.
I mean, is that
I'm thinking like we have a pretty, like our landowner liability.
right?
Very strong in the state of Maine when it comes to like recreational vehicles, like hunting access and all that. Like there is no liability to the landowner unless they intentionally do something. Which comes down to the fact that they put a gate or bar across there. And so like when I look at that a little bit, like I don't really think that kind of, unless there's anything under.
That's part of my concern on. Is there conflict within the law? Because as I understand the law, they have no liability, but they can read this and wonder.
Well, okay, that's
Is
a
it the
good point.
assumption that there's a liability, I guess, like that's my, like.
I would say that municipal attorneys are pretty much in agreement that when it comes to a public easement, where the town has the right but not the obligation to fix it, if the town doesn't fix it, the abutters can. They have the right to do that, but at their own legal risk. So if they're negligent, if contractor's negligent, and you or I drive down that road, even if it's for recreational purposes, we could probably sue that property owner. Now,
So the
there is,
landowner liability law wouldn't protect them?
no, what you're, I know what you're referring to, and that's under Title 14, Section 159A. There's a general limitation on liability for landowners if you open your property up for recreational use. And the idea is that the legislature wanted to create an incentive so that you would allow your private property to be open for passive recreation. People can hunt on it and unless it's posted, people can hike, cross-country ski, whatever, on your property generally. Doesn't get to the right of way.
So if it was a private road, it would come down to it would be more of a landowner liability where the easement actually creates more of a conflict with the like liabilities.
Yeah, if you think of it this way, if a road is discontinued, you have a townway and the town says it's too steep a grade, we don't want to send trucks anymore. It's just used by logging companies anyway. One person lives on it. We're going to discontinue the road, but we'll retain a public easement. So we'll give Corporal McCabe minor damages because it still has a public right to get up and down. Well, Corporal McCabe then has to fix that right of way in order to be able to use it because the town meetings decided, it's just him. You're not going to go out there and send a plow and regrade the road every year. You're going to be liable potentially for a member of the public using that road. Or if the logging company that owns the road down, owns property down the road decides to use it, there's a potential for liability. And so even though it could be open to recreational use, you've also got that public general use and the logging truck use and maybe the UPS driver who comes down to reach your place. So that's the concern that's been expressed by people who live on these public easements, maintain them, and don't want the liability. The idea is we're keeping it up, the public can benefit from it, but the town's not doing anything for the public. I am, and why should I be at risk? So that's a little bit different from the landowner limitation on liability, where you open it up for people to go on your land.
Would that be something that you could look at as like, hey, if it is open to public access, you would kind of mirror that landowner liability?
What if it's not? Because what if that logging land is not open to public access? Or maybe there are 6 houses on this and it's all residential or it's a business. And there's no public access opportunity. It's just a public right of access and keeps the town from having to fix it.
But there is public access. That's the whole issue, as I see it, is if they're not blocked off, the public's using it, whether the landowners, the abutters, whoever want them to or not, they can't stop it because there's a public right of way there.
Well, that's it. They can't, but they wind up having to pay to maintain that road for the
Well,
public.
and I think
use.
that's what Chris is saying. Why wouldn't we extend to them the same protection, landowner liability protection for that road as we would for an actual private road that is owned by, let's say, one of the big landowners? They're protected. I mean, if you go bebopping across Warehouser's Road,
Right.
they're protected. Why
Right.
wouldn't we?
Well,
Shouldn't we apply that same level of protection to this kind of road?
if you thought the immunity should be extended, that would be a reasonable way to do it, either through that law or something like it. To
Right.
protect someone who's fixing up that public
I
easement.
mean, honestly, I thought that law applied.
I did too.
And I know that Stoneville and ATV clubs are certainly working under that pretense. So if what you're telling me, I believe, is that any of our trails on these type of roads, actually, those landowners aren't protected by that law?
Well, let's talk about that for just a second, because you said your trails, are you talking about snowmobile trails?
Stoneville and ATV trails.
Yeah, do you have a right to be on the public easement?
Well, that's been the big debate. We've had town officials tell us yes, and we've also had town officials tell us no, depending on the town. And that, I think, has been the big dispute, in which we tried to address on the ATV side back in 2004 by saying you'll get landowner permission. But it's still been somewhat debated because of that section of law, pointed out to you a couple months ago or whatever, that people interpret that as meaning there's a public right of way, therefore ATVs can go, whether
Right.
the landowner gives permission or not.
No, I agree, and what Brian's talking about here is there's a section where if a public easement is left over after a
Right.
presumed abandonment of a road, not discontinuance, but abandonment. It's, the public easement is limited to pedestrian and motor vehicle access as defined under the motor vehicle law, which excludes snowmobiles and ATVs.
Under the new one.
Under a new one, yes.
Yeah,
But it didn't,
Oh,
it
didn't
wasn't
use
that
to.
way before,
Right, I
and
understand.
so now we still have two different standards up there.
Right. And so now you have to look at how that road, public easement was created, which. Yeah. it's- when that
But I,
begins to-
aside from that, though, I think, I mean, for me anyway, I can't speak for the rest of you, but I think we would want the landowners either way to be covered under that landowner liability law, which says they're not liable for the public's use, whether it's public on an ATV or public in a pickup or
Or walking.
walking or whatever it is. I mean,
That, and do you want to limit that to where the town is not maintaining and plowing the road?
yeah, because I mean, the town on a public way that's maintained by the town, they're covered under main tort claims anyway. So like when we buy insurance to protect the landowners and the trail systems, that insurance does not apply on a public maintained road, like an access route or use of the town roads. The insurance doesn't go into play, but it does cover the landowners where we're on private roads that the landowners have given us permission on. And honestly, I mean, this will be a question now to go back to risk management, but I thought it also applied on these types of roads.
That's why.
But I think this debate over the landowner liability law applying there probably will raise the issue with risk management as well.
There is a question as to whether towns are liable under the Tort Claims Act for any work they do on a public easement, because they have the right but not the obligation to maintain it.
Right.
There is a separate law where a town is required to maintain a townway. And on a townway, if there are 3 or more residents, say the town's really new, they haven't done what they're supposed to be doing for 10 years, they can go to the county commissioners and petition them. And the county commissioners may do what they've said to me and say, Mr. Katsikas, we're the people's court and we're going to order the town to fix that until the court says otherwise. But at any rate, there is a way to fix it. I'm not so sure in a public easement, but the idea being if the town takes the lead and maintains a public easement, then if the abutter does some work on the road, there won't be the protection from liability. But if the town isn't doing the work and the abutter has to, then the abutter would be protected under 159A or something like it. The landowner liability protection.
Currently, they're not protected.
Right.
Because they aren't the landowner. I mean, that's sort of disputed, I think,
they're
but
the-
that's the interpretation.
They're a landowner, but the protection is for letting the public use your land, not for using a road that there's a public right to use.
I hear you. So, but isn't that in dispute whether or not the public has the right to use it? Isn't that why we exist?
Well, no, if it's a public easement, the public has a right to go over it. So if there's a leftover from a discontinuance or an abandonment, generally, not always, but generally, there's going to be a public easement left behind that the public can use, and the town has the right, but not the obligation to maintain.
When they, it's been a long time since I discontinued a road, but when I did, I remember specifically having to have the wording of the article at the town meeting say that we were gonna retain the public easement or not.
It's better form to do that, but it ought to, after September 65, it automatically was retained unless the town said otherwise in the article. Before 65, it was the exact opposite, where you'd have to specify, but it still is good form to say that you're retaining the public easement, so there's no confusion.
But when we do that, and we did, we retained the public easement. If the snowmobile club or the ATV club used that as a trail, part of their
Mhm.
trail system, are you saying that the people who, we assessed damages and gave them the property, they all wanted it done that way, they
Right.
wanted the road private? Are you saying that they would not fall under the statute that allows people access because we retain that public easement over that section of road?
Well, a little more narrow than that. The legislature made some changes to the statutory abandonment statute, so it's not discontinuance, it's abandonment. The public hasn't spent money to fix that road for 30
Yeah.
consecutive years or more, and so we're gonna presume there's no town way there anymore, but there will be a public easement. That public easement has been limited by the legislature in the last session to motor vehicles, which is defined as excluding ATVs and
Right.
snowmobiles and pedestrians.
Okay.
So it's even narrower. It doesn't apply to discontinuances, it applies to abandonments that have happened in the last couple of years,
And that just happened in the last session,
the last session or two, yeah. And it's also, I gave you the Reader's Digest version of discontinuance, that has become more extensive as well. There has to be notice given, and if there's no other public access, there's up to 1 year, well, 1 year period given to try to work out private easement arrangements before a discontinuance can actually happen. So it isn't as easy anymore to
Abandonment.
discontinue a road. Right?
Yeah, so abandonment is now essentially discontinuance, except for common law abandonment.
Except that the process is different, because you can just continue a road that you have been maintaining for the last 30 years.
Tomato plow.
So we're doing our statutory duty to consider these things, right? And it's causing problems.
I feel like I'm on a committee that just, there's a pit in my stomach every time we talk, because it seems like we're never gonna get to, how do you possibly change? We have to change so much of the law to make this work.
Well, it probably wouldn't be a big lift to say, if people who live along a public easement aren't receiving road maintenance and plowing from the town and have to do it themselves.
Yeah.
Then they shouldn't be liable to lawsuits from people who use the public
Right, I
right
don't
of
think-
access,
Who would be
whatever
liable?
that may be. You wouldn't want them to be
Nobody.
liable.
There would be
The
no one.
landowner
The
would not
user.
be liable.
I
The
don't know.
user.
Who would be liable though? That's-
Well, no one would
Use
be.
at your own risk.
Use it, yeah.
So that's like sledding in an ATV in anyway.
Yeah.
Right, well, it's how it should be,
Yeah.
but again, the way I understand that now. We can't, see, the big debate, I think that Roberta actually raised was. Can we not use it with snowmobile and ATV at all, or can we use it? If all the abutters say we can use it? Or does the law actually say that you no longer can put ATVs and snowmobiles down it, no matter what, including even if you're in a butter, which is, I think, what one of the cases came up. There was an individual who lived on it, was using an ATV and got in trouble because you're no longer supposed to be on it with an ATV, even they're the budding landowner.
Yeah, I pulled down the ATV statute trying to get some clarity, and that was kind of fun.
Good
Because
line.
3157A entitled 12, conservation. And so a person can't operate an ATV on the land of another without permission
Right,
from the
correct.
landowner or the lessee. So that's fine. Permission is presumed on designated state-approved ATV trails or areas open to ATVs by landowner policy. Landowner can limit the use of that. And then we go down, operating an ATV upon a controlled access highway. You can't operate on a controlled
Right.
access highway. We're not worried about that. Those are state highways with controlled access that have been blocked off or regulated. Operating a motor vehicle on ATV trail, fine, on a public way. Except as provided in this subsection, a person may not operate an ATV on any portion of a public way maintained or used for the operation of conventional motor vehicles or on the sidewalk of any public way. There are a couple of exceptions, and one of them is that I can go on the distance necessary to cross within no more than 500 yards. So long as you can do that safely, you don't interfere with traffic. If it's been close to winter maintenance. So let's say there's a town way, and towns can do this. It's a town way, no one lives on it, it's used for logging or whatever. And it's too great a grade or too expensive, or the roads in shambles, the town closes it to winter maintenance for up to 10 years, no plowing. That can be done, it's lawful. On that, you can operate an ATV on a portion of the public way when it's been closed in accordance with that. An ATV can be operated on a public way that is not maintained or used for the operation of conventional motor vehicles.
That's what the towns default on by giving clubs trails, because they say, we're not maintaining it for conventional motor vehicles, therefore you can use it as a trail.
And so then the comeback is somebody who lives on the public easement that is open to public access. Not maintained by the town, but maintained by the butters, but is open to public access. Is that maintained or used for the operation of conventional motor vehicles? And the answer is, well, by whom?
Right,
It is-
I mean, that's,
Right.
because what the towns are saying is, we're not maintaining it for those vehicles, therefore you can use it.
Right.
That's what they're telling clubs. I've been telling clubs, go talk to the budding landlords, get everybody's permission, but I've literally been in meetings where the town select board or chair said, you don't need to talk to any of those budding landlords. We don't care what they say, you can use it.
That could be a road that's closed for winter maintenance.
Well, it's not talking about, they're talking about, because we're not maintaining it.
Yeah, you're okay on the roads for winter maintenance, that are closed for winter maintenance, not an issue,
Right.
you're allowed.
The
that
other
under
one is
statute.
question.
The other one that's a problem because it is a public way. In the sense that there's public easement, public has a right of access. But it's not maintained by the public entity. Doesn't require that it be maintained by the public entity, it just maintained for use by standard motor vehicles, conventional motor vehicles. So if I can get my car over it because I've been maintaining it as an abutting landowner. And it's a public easement, I might argue you don't have a right to be there.
Right, well, that's
Yeah,
my
that's my
question
position.
is, how do we, that to me is. This is where I think there's a conflict and confusion in the law that, I mean, we're sitting in this room, we can't even seem to figure it out, and somehow we can make that clearer.
I also do think there is some, like, I mean, I think of the Byron Road up there in Weld, but the ATV trail stops. That's a winter maintenance road. We've never allowed ATVs to ride from Goose Canyon all the way to Weld, just because it's a winter maintenance road.
No, but legally they can.
Right.
I mean, I'll tell you where else you can, it gets worse. We can ride the snowmobile trails all the way down through the main road that's closed down through the White Mountains, Wild River Road, whatever. Legally, by law, we can run all of that, because even the National Forest says we can. Now, we don't tell the public that. And we don't let them do it, because it's a nightmare, because it's a green snowmobile trail. But if somebody does it, there's no way you can actually write them up. Because they're legally able to. And so we've kind of.
I think the
That's a
idea
whole nightmare
behind
we
that
don't
law,
want.
I mean. I think the idea behind that law is for passage in the winter for people that are trying to get to their places where there is no winter maintenance. So that allows, because there's no need for ATVs to ride on those roads otherwise. And I think that's the original intent of that, but
And what about, and snowmobiles, I assume it's the same.
Well,
Well, it
no,
depends.
see, snowmobile law doesn't require you to have landowner permission.
snowmobiles you can ride anywhere as long as it's not posted or you've been told not to be there. There's no, what we would consider reverse posting. So if you have not been told to be on someone's, or if you've been told to be off of someone's property, you can't ride a snowmobile there. But other than that, snowmobiles can go anywhere that they want.
Yeah, snowmobile may be operated on any portion of a public way when it's been closed for winter maintenance, which makes sense.
Right, you can't operate on a public way with a snowmobile, you can't operate on a highway.
I mean,
still have
snowmobiles
that
can do the
500
same as
yard.
ATVs in that you can travel up to 500 yards to cross.
Right.
And then if the town or MDOT authorizes it as an access route, then they can legally ride however long distance down that road, public road. That's designated as an access route, and there are snowmobile access routes in some areas. There are quite a few ATV access routes across the state. But those are on sections of road that the town or county or MDOT is in fact maintaining for regular vehicle traffic.
Rare for snowmobiles because they just don't operate on pavement like
Right,
ATVs.
it's,
We do have one though in Oxbow that's like 6 miles long that we've authorized and they wanted. it.
Dirt road.
No, it's paved
Okay.
road. We plowed
There-
it. They wanted it. So
there are access route, there are snowmobile access routes within some of the built up towns
Yeah.
as well,
Yeah.
where you kind of, I mean, it's not ideal. Any of us that snowmobile don't want to be driving down pavement any longer than we need to. But to get like downtown Jackman, downtown Millinocket, some of those areas, they are running down through to get between the gas stations and motels and restaurants and whatever, and they're designated. But it's
Yeah.
very, it's, I don't know, we probably don't have more than 50 miles statewide on snowmobile. We probably got real close to 1,000 miles on that beach.
There's
It's
a
a big
couple,
difference.
there are a couple of other things that enter in here. One is that snowmobiles generally don't harm the soil underneath, which
Right.
is why they're allowed pretty much anywhere unless you tell them not to. The other thing is that on a road that's closed to winter maintenance or on public easement, if somebody lives on that and is plowing it so that they can get to their house, they can post and notify the snowmobile clubs that because they're plowing a public road privately without public compensation, that they are prohibiting snowmobile use on it. And the reason for that is that it's a danger. If you got somebody plowing a road and somebody's coming the other way on a snowmobile, that's not.
So they are legally able to, even though it's a public easement, to
Even though it's a
prohibit snowmobile?
If it's a public easement and someone is privately plowing it without being compensated by the public, they can prohibit snowmobiles on it.
Where is that, Roberta?
It's in the same law here, it's in one of those subsections. The thing that's not clear is when a road is closed to winter maintenance. Most towns will say that private individuals cannot plow it, and I know 2 cases where towns have closed a road to winter maintenance. I know 3 cases where towns have closed a road to winter maintenance when somebody lives on it. And then they tell the person, you can't plow it. Well, how are they supposed to get to their house? You just prohibited them from living in their house for the winter. That's a taking of access without compensating them, and that's unconstitutional.
Presumably, if somebody's living there year round, the town isn't going to close the road.
They
for
have.
maintenance, but
They have. There's one in Livermore and there's one in, oh gee, I can't remember what the town is. I know there was another one in Jackson a few years back.
And there's been a few more in recent history where people have moved in under COVID and are now living in some of those types of scenarios that previously they weren't. I think there's even more than maybe the 3. I think. And I know of a couple of cases, they told them, you know, just use a snowmobile to get there. And I know of a couple of cases like with camps and whatever, people were doing that. But then all of a sudden, the going to camp became, we lived there year round, and that becomes a bigger issue now. And so if they can't plow it, or if they're liable if they plow it, that's an issue. I would agree that I think we should at least try to address that liability and make it the same as the liability on a regular private road. Protect the landowners or the abutters the same way, I would think.
we're really working, we started with one issue and we wound up on another.
Yeah.
In a sense that we're talking first about the liability of a landowner who has to fix the road because the town, the public easement because the town won't. And we've been talking now about the operation of ATVs and snowmobiles on you know, recreational use for public easement. How about if we, that's an issue. It's one we can address under the prioritized topics for recreational users. I think what I'm hearing is on the first part, working with the existing limitation on landowner liability that exists to allow people to use public property for public recreation and expand that to encompass someone who's trying to maintain a public easement with their own money where the town won't. So that's one set. I think that's an issue that Roberta had raised early on, and I think we heard it from several other people. Is that something that you can reach consensus on that we should say is an issue that we think needs follow-up?
So I have a question on that. We have to be really careful about landowners and putting the responsibility on landowners, because if you do that, these guys are gonna lose a lot because ATVs and snowmobiles primarily go on private landowners' property. So you do have, I mean, I know I hear you talking about it, toward it, but you have to be careful because if you lose the landowner and they close their land, then whatever we have for winter is gonna be even more jeopardized.
I understand. I think that goes more toward the second issue we're gonna get to in just a minute. This first piece is, we have a road, it's a public easement. Gonna pick on you again, if you don't mind, thank you. Corporal McCabe lives on that, And the town discontinued the road but left in public easement, so Corporal McCabe can get back and forth to his house. Town doesn't want to spend any money though to fix the road there, so Corporal McCabe's going to have to fix it himself. We don't want him to get sued when the public uses the road just because, unless he was negligent, unless he went out there and said, I'm gonna put boulders down, darn it, and you know, good luck to them trying to get over this. I can get over it with my 4x4, but no one else can.
Which is the same case as people putting the gates up because they own both sides of the road. And
Sure.
that's what I'm hearing you
Right.
speaking of.
So what we're trying to do is say, if he responsibly takes care of the road, maintains it and plows it, so the public can use it as well as him, he won't be liable when the public uses it if someone gets a flat tire or there's, you know, it's just.
I honestly think something like that would encourage people to open access.
Yeah.
Because
It might.
it loses the liability of, like, that's the fear that you see in a lot of people is like, I mean, when you talk about the plowing of the road, I mean, it's, their fear is that they're gonna get sued because a snowmobile comes around the corner.
Right, so if we guarantee they can't be sued as a landowner or a budding landowner. That shouldn't cost us anything, if anything, we gain, right?
Right.
Well, you would think so, but, and so basically this would be where the towns don't maintain the public easement and the private property owner does in order to use the access. Then that person would be, if they do it prudently, reasonably.
Yeah.
Then they'd be free from liability. If they do something foolish, they are their contractor, then they could be liable, which is exactly what happens under the landowner liability
Right.
law. If you have some, you know, a pit out there or something that's a huge danger and you don't warn the public, you're not immune from liability for that if people come on and use your recreational land.
How
But-
do you prove that? How do you prove that they did it?
That, if you go to court on that piece, that's in the law
The
now.
reality.
Yeah. The idea is you can't create some nuisance that you know of, something that's really dangerous to the public and then invite the public onto your land. And that's already baked into the state law right now. We're just extending it to this.
That Corporal McCabe can put an obstacle up and then say, well, I didn't do that. So, I mean,
Yeah, well, that,
he would do that.
I'm gonna trust he would.
You're really getting picked
I
up.
mean, that, we had, as an example, different, it's not the road, but we had somebody string a cable across one of our rail trails
Mhm.
years ago. We, you know, to this day, we don't know who did it. So that could happen, obviously, but in other cases, I mean, recent history, we had an individual do the same thing and, you know, bragged about it, and he got a visit from the wardens and everybody else because that was malicious intent, and you can't do that, you
And
know.
if somebody did it on their private property and a person was injured,
Yeah, they'd be.
there'd be
Correct.
no immunity under
Right,
that.
exactly, and that's what we
Correct.
explained to this individual, that if somebody gets hurt and killed or whatever here, you're the one going to jail, but. And that problem went away because it was very clearly malicious,
Right. Okay, so that's a concept. Here's what I'm proposing we do. If we can come to some general consensus, I'll work with Vivian, but we'll put together a draft. We got a really short turnaround time. We got 2 weeks, but we'll get a draft together within the next week, shoot it out to you to give you some time to think about it. And then we can adopt that draft at the next meeting with any changes that you think appropriate.
Along those lines too, like I know
Sure.
it came up a little bit with like the logging and stuff like that with like, say, it's my road and I'm maintaining it and the logging company comes in to log past there. Like, I noticed that there's no liability for the logging companies to reimburse those people that are, and I think that that's something that should kind of like maybe fall along suit with that, where if they're doing work in there, that they should be liable for that when they're coming out. That seemed to be a common thing that was coming out of.
right, but now you're
There is.
making liability, you're establishing liability. One would like to think they would just be responsible.
I know,
But they're not, obviously. And that's the same thing
Easement, that falls under.
on any kind of use, right? I mean, some of these people fix their road all up, get ready for winter. And I say their road because it's really not their road at this point, it's just public. And then hunting season, you know, we're in there with 4-wheel drive trucks or whatever else, and it gets stove up and now they gotta fix it again. But I don't know how you can,
Make someone,
I mean, as soon as you go the other way and you make somebody liable, then you get her concerned, all of a sudden, people
Well,
get really nervous.
There's
Remember
already
that,
existing law too. One is for damage to a public easement. There's a civil pursuit path and there's a criminal pursuit path. So if it's intentional, willful, then it's criminal. And if you take your skidder down someone's road and it has a public easement and you've damaged it, then it's the same as if it were a town road, you're liable.
and that's.
So that's already in law.
Those are,
you know,
that's all.
generally it's the town that would do that because it's the
They go
public's
after
public
that.
access. Right, not the individual, but the public could be taken care of.
But it would be the individual that damaged the road. So like you.
Right,
Right, they would
Right,
be-
you go after
Yeah.
the logging company or the
Exactly.
ATV rider. but it
And
would
that,
be the
those
town
exist
who-
the same.
But it would be the town that would have
No,
the
the
right.
No, it's the
landowner.
individual on the discontinued road
Okay.
has the ability to pursue both criminal.
So Chris could go after the logger
Yes,
in that scenario,
yes.
but he,
How-
but he would have to, you'd have to get a lawyer and.
Well, no, there's a criminal path. So there is a Title 17 law that he can enforce.
If it was. criminal.
If it
But I mean,
What is-
a logger hauling wood out on a road that damages the road, it's never gonna be considered criminal. That'd be a. civil
There would be a
violation.
civil, but it would be the same as if. he
So it doesn't
had
seem like any of these
continued.
folks that have had those issues have taken that road.
I mean, yeah, because there's a lot of them and you're complaining about that type of thing.
Is it new? That,
Mark, we've been droning on and you have your hand up. What comment would you like to make?
Thank you. It's quite all right. I just wanted to make to add to your consideration. And I know some changes were considered a couple of years ago, but my comment is in regard to the unsuspecting couple that purchased property along one of these roads. And would it be the purview of the committee to consider recommending changes to the main real estate transfer tax declaration form or some other way of communicating and identifying the status of these roads before they sign on the dotted line and own them? So that's my suggestion. For
Well, right now, there is a real estate disclosure form that has to be filled out to talk about whether you know whether there's access and what that access is. Unfortunately, given all the issues you hear about today, it's sometimes hard to figure out what the status of that road is, right? And so many times it's unknown. But it's a good point, just like if your property is in tree growth, you have to note that on the real estate transfer tax form. And if you're in shoreline zoning, that has to be noted along the way. It would be nice. I think we have the real estate disclosure now. Maybe let's work within that, but it's a good idea. People need to know and be informed purchasers when they're buying properties. They can minimize the risk of getting into one of these issues. And it's something we'll think about.
And something to consider recommending to tighten up in that process. I suspect when a young David and Roberta Manter purchased property in Fayette, prior to purchasing it, had they had such a disclosure, they may have reconsidered.
It said on the deed that the road was discontinued. And when David checked with the town, they told him, we ain't got nothing to do with that road. And they showed him paperwork that said it was discontinued in 1945, which was well before 1965 when they started retaining easements. Only when it went to court, the court said that because there was a line in there that said to be retained as a private way. And here's where that confusion comes in with that term. A private way is not a private road. But how is he supposed to know that? So he was told that it was closed, discontinued, private way, subject to gates and bars. He thought, good, it's my road, I'm responsible for it, I will have to fix it. There's, I don't have to let anybody else in. Not true.
Therein lies the basis of my suggestion.
And the problem with that is, given that can happen, how do you check the box? How do you know which box to check? If you're, and who should check it? Is it an attorney, a municipal official? Is it the buyer, the seller? When there's that much uncertainty, I don't think anybody wants that risk.
As I understand it, as it stands now, the realtors are saying that it is the seller who is responsible for telling the realtor what to put in that box.
Mhm.
And lots of times the information the seller has is not accurate. And that's where we're running into problems. with it.
Or it's not sufficient, so. But it's certainly a consideration. It's a question of who knows what and who should have the ability, the duty to disclose.
Thank you.
Thank you.
I have a question, if I might.
Mhm.
So, yes, so you have the logging truck come in and the logging truck is found to be responsible because he made a mess of the road. I get that, but what about this four-wheel vehicle that you're talking about that just went in there to hunt? It's a one-time thing, he's in and out, you don't even know it, who's responsible? Because the road is a mess after that. After whatever, his moosey, it's very heavy and, you know, I don't hunt, so that being said. Who's responsible when a private citizen comes in there, not a logging truck, because the logging truck goes very slow, and we can handle that, we can catch him. But what about this four-wheel drive vehicle? That messes up your road? Is there a way, I mean, unless like a Roberta goes out and takes a picture of his license plate or the make of his car. Barring that can always happen, because it can't, but who's gonna be responsible for the road when something like that happens?
Yeah, that's exactly what I asked back when they passed that law, the two laws, the one that says that it's a class E crime to damage a public easement with a motor vehicle, and the one that says that a landowner can sue someone who damages their access over a public easement. I said, this isn't going to work because the ones who damage it come in the middle of the night and they're gone, or they come in when you're not home and they drive through and nobody sees them, but you come home and you find there's these two ruts right down the middle of the road. And they said, oh, no, this will work really well. We've already got a similar thing for damaging cropland or timberland. And they assured us that this was going to work. And I said, yeah, we'll see. And what we're finding out is that unless you have pictures of the road before they drove through, and pictures of the road after they drove through, and pictures of the vehicle driving through and damaging it, there isn't a whole lot you can do.
So we're talking about security cameras on every public easement that's privately maintained.
We do as many, we put as many as we can.
In Augusta, we had an 18-wheeler that took out a bridge. Nobody knows who did that. It was a crime. It is the exact same situation that happens on a public way. You have to catch somebody in the act of doing it.
You
So
know,
really, it's no difference.
But how do you catch him and make it stick?
Well, that's a double-edged, that's two
Yeah,
parts.
see, I mean, there's prosecutors involved in that, there's police involved in that, there's an investigation involved in that. It's identical to,
Because I find
A road.
security cameras are great to catch somebody in the act, but they're not good in court.
We
I
can be
mean-
good in court. If they were established by law enforcement, if the camera put it up, and there's a process in place, they're very good in court.
Well-
If I put one up and I go to court and say, oh, this is what I did, but there's no verified through law enforcement,
Right.
then they may say,
The
yeah.
problem is too,
That's
is
the
the
problem.
unpredictability of it, because Roberta's road, it may happen every 10 years. But it's statewide, you're having 100 a year.
Yeah.
And you could leave a game camera out there till it grows into the tree and you may not catch anybody.
You shouldn't have to get to that point.
No.
I guess, I was saying it kind of kiddingly, but, well, you'd think that they'd find a truck that had a top missing or
Still
something.
Is it the can opener that everybody hits?
yeah, it's the one that they
one
took it
down
out,
by
no
our
one
office?
reported it. There was like massive damage. They had to shut down the
Mhm.
gate and then they rerouted traffic for a year and a half.
Yeah.
None of that has
Wow.
ever been
One
found out, and that's in
suggestion that I've made-
Augusta.
One suggestion that I've made, and maybe Rebecca or Tony can comment on the legality or the effectiveness of this. What about allowing people to put up a sign that says, warning, road not maintained for public use, damaging a public easement with a motor vehicle is a class E crime? That would at least put people on notice that if you damage this road, you may be held responsible for it. And maybe it would make people think twice, and then if we catch a few of them and actually manage to enforce that, then maybe word will get around that if you see this sign, you better be careful how you use this road.
So I think the sign's a great idea, but I also know, reading through some of this, there's an awful lot appears of conflicts where you live on the road and I live on the road and we don't agree with the sign being on the road. And I saw a lot of that. Really, I find it pretty sobering that neighbors are fighting with neighbors over the use of the road. So that's part of the issue, because when you got 5 people live on this road and one wants it gated and 3 of them want it, want cameras and restricted use, and the other 2 want no limits to anybody. How in the world do you manage that? I mean, that's a court case. That's all that is.
Mediation.
Well, if you, again, you don't get the mediation usually until there's a threat of court. But that's just, and I don't know how you fix that. I mean, I've been reading some of that going, wow.
Well, if it's a private road, just solely private road, 4 or more lot owners and budding lot owners can get together and form a road association. They can incorporate it. They can elect one of them as the road commissioner, and they can take care of their own road, send an assessment out, but it requires them all to come to an agreement. And there may be some along that road, maybe 4 out of 6 agree, and the last 2 who don't agree are the last ones in, and they just want to take their skidder over everyone else's road. Yeah, that's a lawsuit waiting to happen.
But can that road association actually be established on a discontinued road?
If there's a discontinued road that is a private road, there's no public easement that's retained, yes.
What happens if you have a road association and the road becomes a public easement?
It's an interesting one, because people don't usually, you're always in hope that the town's going to come in and fix it at some point. So you'd hate to go to the trouble of starting a road association where you're trying to convince town meeting to do something. I haven't seen that happen too much.
The law says that you can have a road association on a public easement. But the problem is, if you compel everyone on that road who maybe doesn't want to be a member of the association, but you've got those 4 who form the association, if you say you have to pay dues to maintain that public road, you can't compel a private landowner to maintain a public road with private funds, because that's unconstitutional.
A public road or a public easement?
Public easement. But a public easement is open to the public, so essentially it's a public road. You're maintaining it for public use with private funds. So this is something that.
But some private roads have bestowed a public easement for the purpose of winter maintenance to communities in order for.
Yeah, that's kind of a different situation because it's
That's
agreed
essentially
upon.
that. It's an easement.
Right, but where it's a road that was discontinued, but remains a public easement, then, how can you have a road association and force people to pay to maintain this public road?
But if it was a private road to begin with,
If it was a private road to begin with,
and a road association was established, and everybody's paying dues,
yeah,
5 years down the road,
Town of Wyndham,
they become a public easement. The town accepts a public easement so that they can provide said road association some money.
that's a little bit different because it's been agreed upon and because the town is usually only providing winter maintenance and the road association is providing summer
Or
maintenance.
cash.
And most of these, hopefully, are dead ends that don't go anywhere except to those properties, so there probably isn't going to be a whole lot of public use.
And the real fights on that tend to be in recreational areas, lakes, ponds, where there are roads, seasonal residents, and I pay my taxes here. I'm here in the summer. I've got my nice house, and you don't give me anything for the tax money I spend. Can't you at least grade the road once a year? And the answer is it's not a public way. You know, nothing's doing. But there are some towns that adopted the fiction of, well, we'll put up a sign and say the public can use it. And maybe after 30 years of doing that, then there'll be public rights.
We deal with that a lot with ATVs
Okay.
on private ways down by lakes, golf carts, all that stuff. And Like it's private road, private way, like it's nothing we're touching. Like you're good to go, like
Right.
come to an agreement.
So we're asked to consider property owner liability with regard to public use of an abandoned or discontinued road, and where that really comes up is in the public easement situation when that's retained and people have to fix it because the town decides it doesn't want to do that, which it has every right to be able to do. Public easement retention over an abandoned or discontinued road, including the scope of permitted and actual public use. This is something that we shall consider, so we shall. So it's an instance where the public easement is retained. Town is discontinued, subject to a public easement to allow the public to pass over it. And the problems are that not only will the people who have houses along the road be able to go up and down to access their houses, but the logger has the right, as a member of the public, to use that to access the logging road, say that the skidder going up there. The ATVs potentially can use it. We're not quite sure,
Right.
right? But
Not now.
but potentially, if they do use it, you've got all of this public use. Some of the people who live there, some of the people who want to recreate by going down the road to that. We do have an issue with regards to the scope of permitted and actual public use, and that is ATV use. So that's one issue.
Well, I think it's definitely, I mean, they limited ATVs. On the new ones, the old ones remain unclear,
Right.
but based on what you said today, I think it's also unclear if snowmobiles can use in some cases because they've excluded
Anything.
motor vehicle, right? So if ATVs and snowmobiles aren't registered as motor vehicles, which they're not, then they're both excluded. And what's unclear to me is, are they excluded no matter what, or are they excluded unless they have landowner permission? Because if I'm the abutter with an ATV and snowmobile and I'm now excluded on my own access, say nothing about an ATV or snowmobile club.
Mhm.
Was that really what the law did? But some are interpreting it, that's what it did. I don't know.
I think that's a good point. The road that we're on, part of it has been used as a snowmobile trail for years. And the landowners have not given permission for it to be used by ATVs, but they have no problems with snowmobiles using it. And my husband finally became a member of the snowmobile club, even though we don't have a snowmobile, because if the snowmobiles pack the 2-mile loop around, he can take his service dog out for a walk on the snowmobile trail all winter. It's great. So he's been helping maintain the trails. And as I said, part of it comes right straight down the discontinued road.
Well, and I mean, there's a lot of discontinued roads out there. Ryan can speak to it, John can speak to it, that we've been using for ATVs and snowmobiles since the 70s. And 88, since the late 80s in many cases with ATVs, and some of them we have been shut off with different of both over time. I think in New Sharon at one point, all those discontinued roads were open to both. And now none of them are open to ATVs and about half of them are open to snowmobiles. And that was all because of a couple of private landowners basically went after the town council on it, and they got direction from attorneys that said, you're out of line here, just carte blanche opening all these up. So they went the other way and closed.
And it's funny too, like you talk about Fayette and your road being like ATVs using it, like from our perspective, there's no ATV club in the town of Fayette. There's no maintained ATV trails.
Right.
No one should be riding there unless you're a landowner. But the problem is when it comes down to that public easement and the use of an ATV on it. But from our perspective with the warden service, there should be no one riding there unless like Roberta's out riding on her road. Because there's no maintained club trails.
But then you got these, like Mercer.
Yeah.
No club.
Yep.
No trail. Every road in town.
Is
the
open.
Town of Mercer open.
Yep.
To ATVs.
Yep.
And so then you get use occurring all over the place.
Right.
and-
Which then it floods
bumping up
into
the
those-
MDOT's, parts of the road that they're funding. And you got town select board saying, this is what we're doing, and we played no role in that. Law enforcement didn't, we didn't, MDOT didn't, and that's what they're doing. And the law allows them to do that. And people don't, a lot of people don't want to see that change, but that's certainly, when we got the ATV access route in place. it originated in Mars Hill, very first one. We resolved the issue with the seed potato fields by running them down 3 miles of dirt public road. And everybody was happy, and then the DA sent the local ordinance to say, that was really well and good, but you can't legally do this, but you're exceeding the 500 yards. So they got legislation passed to allow access, and that's how it all started. But that was the intent, is to connect trails, get around things like that. That's now been taken to where you got towns that opened every road in town with no trail, no club, no connection. And it's like, really? This is what we want to do? But
And sometimes you have cases, like I mentioned earlier, where if they don't do that, people can't get from where the trails are to the downtown.
no, right. I mean, it's appropriate in places where you're using the, trail comes in and you use up the roads to get into town, like, many towns, Jackman, Greenville, Caribou, Prescott, all of it. And so, you can't throw the baby into the bathwater, but the unlimited regular, of limits there, it's just very. We see areas where they've opened up all kinds of stuff that arguably could be considered inappropriate by some. It certainly wasn't the intent of the law when we were in front of the legislature.
But God bless local control.
Yeah, I know, that's right. And that's, we all get that, right? So that's the struggle.
Is it a good idea that there is a public easement retained generally in discontinuance and abandonment?
I think it's a good idea, but having lived it for a long time now, I do feel that there should still be some obligation on the town when the decision is made to compensate for the maintenance of a road whenever it's publicly retained, like when there's a public easement retained.
If the town isn't going to maintain it.
So is the current public easement, let me make sure I understand that. You can't use an ATV, but you can use a regular motor vehicle.
Yes,
And that's where,
well, we're not sure on the
Well,
ATV,
I
but
think that's arguable on the public easement not being used for an ATV.
yeah.
Right,
think-
no, I
think that-
agree.
that-
Yeah.
But but it's very clear that. When we retain a public easement, I can take my 4-wheel drive down through there.
You can take your car down there.
And that's where, granted ATVs can do significant amount of damage, particularly if it's a lot of them. But what we see a lot is hunting season with 4-wheel drive vehicles.
Yeah.
And so I agree with you. It seems like if we're gonna maintain a public easement that says the public can do this, why is it Roberta's responsibility to be stuck fixing 3-foot ruts at the end of every hunting season, that. And that's getting worse every year because the freeze thaw thing is happening, we don't freeze up, and bury it with snow and life goes on until spring anymore. I mean, this winter is a perfect example.
It's only gonna get worse.
And so I get that if I was in that scenario and. I would understand that. I mean, talk to Rick Laflamme, Chris's counterpart, he's on a road up there that. The private camp owners share along with the ATV and snowmobile clubs. And the rest of the story is we funnel. $3,000 or $4,000 a year into that road through the ATV program to kind of keep the peace and everybody shares. And if we were doing some level of that statewide, I think that would resolve some of these issues, but.
I think the other piece of that, to kind of go back to what Ryan was talking about, discontinuance is a public process that involves the legislative body. And the ATV statute says the municipal officers. So there is no public process that is part of designating an ATV trail. And they can't even entertain one, so you can petition it as a public process as well.
You mean on an access route?
If the Title 12, that section of law specifically states that the municipal officers designate.
Right, but I mean, there are.
But there's
a
no
lot-
public process.
Well, there is
as
in a
part
lot of cases, because I know several where they flat refused to do it until it was on warrant.
Mhm.
So they
But that's,
made
but
that decision.
actually, like, that's not what the law says. In order for them to designate it, it's the municipal officers.
Right,
And
well,
they- So
again.
like, even if it's on the warrant,
Well,
That's not the,
what's, I guess the difference is,
Mechanism.
I've seen. You know, the board say, we'll make a decision. Right, wrong, or otherwise, and then I've seen them say, we're not gonna make a decision until we hear from the public on this, either in a public meeting. At the regular town meeting, because they put it on a warrant and let the town vote, they still make the decision afterwards. The vote doesn't per se, in fact, I was at a meeting where the vote went one way and the board went the other way and said the vote doesn't mean anything by law.
and that's the problem.
Yeah,
that
it wasn't,
statute,
and I was like
because-
banging on the meeting because it wasn't friendly
And I think MMA's general advice would be, don't do the public process.
because of that.
Because you're not covered for doing that, and you're gonna maybe tweak a lot of people. Doing it, if you're moving in that direction because of the way that the statute's written, as municipal officers,
But back to what you said at the beginning,
the public
the
process.
discontinuance does require the public legislative body, which is the town meeting. Unless you're in a town that has a city or town council that has given that legislative authority to the council.
One of the problems with that, though, Ryan, is that when you discontinue a road by vote of the townspeople, if there's nothing mentioned in the article about retaining a public easement,
Right.
you automatically get one. And the people who are voting on it may not know that.
Right, but what I'm saying is if that happens and a public easement is retained, there should still continue, there should be some financial contribution.
Right, I mean, I think that would resolve some of this, right?
But who's going to make that contribution?
The town.
The town.
The town would have to continue, the town
Public
would have
comment.
to fund it like they fund any of their other road maintenance issues, but how
So when we had to come up with our three things here, that was one of the things that I wrote quite a bit on here. Is there shouldn't be any automatic anything. It shouldn't be automatic public easement, or it shouldn't be automatically private. I kind of laid out a process in here, leave it up to the abutters, which may be a problem, but leave it up to the people that live on the road to make the decision. And then they make a recommendation, there's a public hearing with the board, and the board tells them, here's the process. And then ultimately it leads to a town meeting vote. And the town could go along with what the abutters suggest. The abutters may say, we want a public easement, or they might say, we want a private. Okay, their recommendation goes to the warrant article, and then the townspeople vote on it. If the townspeople vote against it, or if they vote for it, that might lead to public money that might be needed. And that's where, Roberta, you had mentioned the minimum maintenance. I kind of laid out a thing in here about what minimum maintenance would be, depending on what the town budget is and how many miles you have. That you could allot up to a certain dollar amount, it might be $1,000. And then maybe let the people who live on the road decide who's gonna do the work, but ultimately the town might pay them up to that $1,000, whatever the amount comes out to be. But the bottom line was, don't have anything be automatic. Leave it up to the people to decide, and then have it ultimately be a town meeting vote. Then everyone should have agreed along the way what it ought to be. Because I think the automatic, whether it's what happened pre-65 or post-65, when you have something happen automatically, that's gonna irritate half the people.
Right, all the time.
Well,
So if you leave it up to the people to decide, which may be a difficult thing to accomplish, but leave it to the people to decide.
Is that not what's happening now? Not that discontinuances are happening on a regular basis, but that's what the statute is now. The statute is that there's this public process, there's a declaration, there is notification. There is whether or not it's going to be retained or not. And towns can do minimum maintenance already. But the legislative body has to appropriate that
Right.
money. So there already is that ability.
Well, I think there are two things with that. One is that towns may decide not to do even minimum maintenance on a public easement, and then people have to fend for themselves.
Right.
But I think that the bigger issue, Pete, I'm gonna disagree with you on this,
Yeah.
respectfully. Or as attorneys say, with all due respect. But no, I think the reason for the automatic retention of the public easement back in 1965 is an important one. No one wants to landlock a parcel because many of us live on roads where it's always been a town road. And there's no private right of any access to our house in our deeds, because we're on a public road, and public road may have been there for 50 years, 100 years, 200 years. And so if you take away that public road right, unless we were in a subdivision, which has private and public road rights, if you're just on a plain old public road and it's discontinued, you might not be able to get there from here. And so that was the whole idea of having that automatic retention of a public easement, to ensure that there's a public access, a public right of access that will allow the people who live there to get to their houses. The unfortunate part is that it doesn't necessarily include a maintenance obligation for some public entity, and it allows the public to go over. And so the logging truck, the ATV perhaps, or whatever, can go over and potentially damage what you do. And I think those are the effects we're seeing. But I think that it would be, I think it would be a mistake not to have the automatic retention of some right to get to the house. In this case, it's the public easement, because otherwise you could wind up being landlocked, and that would be a bigger problem.
It's also the only access piece sometimes for people who have neighborhood disputes. The public easement is the only guarantee that they can get through against an adverse neighbor.
Right, yeah, we saw some of that.
Mhm.
But again, doesn't that get back to what Brian said, is it maybe mandating some level of funding with a public easement rather than giving them the option? So towns know, okay, you're abandoning this, but you're keeping a public easement, and with that is some level of responsibility.
Well, there's two ways to do that. One is to say the town can take care of it. If it agrees to take care of it, fine. And, but if not, then they're going to pay damages, which is, I think, what Ryan was saying,
Well, pay damages to the
to the
butters.
landowners.
That already has to be done, right?
But what
But
usually
the ongoing
happens,
maintenance maybe isn't part of that calculation, and maybe you could work that in.
what typically happens is municipalities will say, well, if we're gonna discontinue it, and there's not a public easement retained, then we're gonna have to pay some real damages. But otherwise, if there's a public easement retained, people can still get there. So, you know, $1 damages, and we'll discontinue it, and we're all good. That's,
This is where I get into arguing Jordan versus Canton, and I agree.
I thought we were going there.
Yeah, you led up to it. It's a great segue. Yes, I agree with you, Rebecca, that Jordan versus Canton applied to a law that no longer exists.
Because it was unconstitutional.
But the reason that it no longer exists is because it allowed public use of a road that was not publicly maintained, and the court said that that would inevitably destroy the access. And destruction of access requires compensation, and the law didn't provide any. So now you look at what we've got in abandonment, particularly, discontinuance, there is a process for determining damages, but it's one-time damage when they discontinue the road. So you discontinue the road, the person who wants to get to his property rebuilds the road, somebody comes in and destroys it, he's just lost again. He rebuilds the road again, somebody else comes in and destroyed it, he's just lost again. How do you compensate for that repeated damage that's going to happen in the future? And this, I think, is what Jordan versus Canton was getting at, that the public is going to keep destroying the road. And the decision even says it doesn't matter what the legal status of the road is. What matters is the factual and actual consequence of that legal action. And in the case of a public easement, the actual consequence of a public easement is that it will repeatedly get destroyed. Every time the landowner tries to rebuild it for its own access, somebody is going to say, oh, look, we can get in there now with our log trucks and harvest our land, and the road is gone again. In the first 20 years or so that David or I lived on our property, he was there 10 years before I was, but in those first 20 years, we had a different logging operation in there about every 2 years. And every 2 years, he would rebuild the road, and the next year somebody would destroy it again. So how do you compensate that by making a one-time compensation, particularly in these towns that say, well, you know, you're not damaged because you still have access over the public easement, so we'll give you $1. Well, that does nothing towards all this repeated destruction. So if the town could be responsible for keeping the road just to a minimal standard, just keep it passable. most of the people on these roads would be thrilled if you come in a couple of times a year and grade it and put a load of gravel in the worst mud hole every year. Eventually, by doing that year by year, the road is gonna get to where it stays pretty rough.
Should be part of the logging permit. They have to leave it as they found it.
Yeah, that would be a good piece of it too, because as it is now, they say, no, we have a public easement, we have no responsibility to it. They use the road and they leave.
Who issues that logging permit?
Must be forestry.
Forestry.
Yeah, like they have to have a logging permit at every logging operation. It says, this is what we're harvesting.
Mhm.
They have to have their harvesting permit there. And that should be, like, that would be a good stipulation if, like, for the logging, it's like, I mean, if you're logging in there, you have to leave the road as you found it when, like, your forester has to come in and do a forestry plan. So they should look at it and be like, okay, this is what documented the road looks like. And when they leave, it should be the same way that they found it.
Well, yeah, and I don't know how it works on public easements strictly, but like on roads that are closed to winter maintenance, when a logging operation was in. Towns do have the authority to adopt a, what is it called?
Bond.
Yeah. but
So
it's-
weight limit.
Well, not a weight limit, no, but like an ordinance that basically requires the logger to go into the town office. And get a bond and get a permit and all of those things that if there is damage.
That's on an easement.
No, that's on a road that's
town road.
closed.
Oh,
to
yeah.
winter
But
maintenance.
if it's a
I
public
gotcha.
easement, they
Yeah.
technically could do the same.
I would
thing.
think so.
Yeah.
I mean, that would solve that
The
issue
town would though.
very
It
quickly.
would have to be the town.
Right, so you'd have to get your town to be willing to do that.
And I believe though, that ordinance might fall under the law that allows even the boards to do that without legislative body approval. I'm not sure.
Yeah, it's a
But
bond,
allowing it and
yeah.
mandating it are two different things, because if it's just allowed, they may not do it.
I think
It's
it
like
should be part of the permit.
the effort to inventory roads years ago. We finally got a bill through that said that the town should inventory their discontinued roads, but at the last minute, it got changed from must to may,
Oh, yeah.
and nobody did.
Yeah.
So I take it there's nothing now in a logging permit that says anything about the road.
That's what I was just wondering. I don't know if there is, like, I'm not.
Like a
familiar with the
forestry
logging
issue
permits,
permit?
but-
Right.
I don't know, I don't think so. There could be, but I don't think so, because you see them posted, they're posted on. The wood yard of
Right.
where they're cutting. So they might travel 2 miles down one of these roads before they get to that point.
I know one case where there are two parallel discontinued roads. This one is the one we live on. This one, nobody maintains. There's a wood lot on this one. And the guy who wants to harvest his wood off of this wood lot doesn't want to use the road that nobody's maintained. So he gets permission from a landowner on this road to go in, cross his land, harvest his land off the other road and haul it back out.
Yeah, 'cause you have to build the whole road to go in there.
I do know there's one case in Millbridge where a logger used a public easement, left the road in a mess after the private individuals who lived there had spent big bucks building the road so that they could get in and out to their house. And they tried several agencies to try to get the logger to come back and fix the road. And finally, I think what they did was they went through the Forest Products Council or somebody like that.
Mhm.
And the mill was notified, do not accept wood from this guy until he goes back and fixes the road.
Hmm.
And he came back and he graded it and left it. And he didn't do an awfully good job of grading it. He didn't put it back to the condition that it was in before. So
The other reality that's out there, unfortunately, is you got a landowner. You got a forester for the landowner. You got in many cases, somebody who's harvesting the wood. And somebody else that's trucking the wood.
Yeah.
So you got a whole bunch of people going.
Mm.
And it makes it very difficult, which is why you end up, if anything, you end up with a court case, because. Or Chris or the forest ranger, who else, it's like, how do we, who did this? And who's responsible? And that's, the days of Great Northern owning the property and the crews worked for them and the truckers worked for them and all that, that's all history. That doesn't exist anymore today. And we just lost the case, state of Maine. We were cutting wood on Duck Lake and the woodcutter just said, I'm done, out of here, because the mill that won the bid to take the wood was different than original plan, and now he's gonna have to truck it further. He said, so my bid is no longer valid. So he left the job site and the whole thing's falling apart. Now the mill's falling, we aren't getting any wood, and we're not cutting any wood, but there's multiple people involved in it. They all went that way years ago, thinking we can build the road cheaper and we can do this cheaper and whatever, than just all in one. But now it's coming full circle. And everybody's tight for the dollar, so if they can use somebody else's road and get away with it, they will. And if it's frozen, they're probably not gonna hurt it, but
Yeah, that's.
we get winters
Well,
like
every
this.
year there are more and more attempts to limit municipal authority to restrict any sort of logging operations. Because there are continual thaw zones in January where there typically weren't anymore. And folks can't get to their woodlots during that pre-thaw periods, and they're
That's-
frustrated by the fact that municipalities don't want to be continuing to maintain those sections or have them damaged because they're running through the mud.
Look at the scenario in Oxbow you mentioned, right? I mean, they destroyed that road. And that was a huge uproar over that, and that happened in the middle of winter. I mean, this coming weekend, we're gonna see this happening, in real world.
Yeah, this is another thing that might help the definition of what is a frozen road. Because, you know, on our road, we had one situation where the road had thawed completely. And then we got a cold night. And the logger said, we'll go to the roads first, and came in to get his wood out. And we called the whether it's the code enforcement officer or somebody called them. And they came out and they said, yeah, the road's frozen. Well, yeah, the top inch is frozen. But under that, it was all soup. Then that's not gonna hold up a water truck. So how do you define frozen?
Well, that was one of the other things that I don't know how we fix this, but all of these definitions, whether it's private road, private way, whatever, they vary. Like Title 12's public way, is that the same definition as some of the others? I mean, you wonder if you could get all of the definitions the same within the statute, that might make things a little less confusing, but I don't know how you can do that.
One advantage we have now is that the computers, you can type in a word search or a phrase search, and it will tell you every place in the main statutes where that term shows up. We didn't have that back when we started on this, and I suggested at one point, can we make all the terminology the same through all the statutes? They don't, no, we can't do that. I don't think it was so hard now.
Well,
I think there
any
may be
one
unintended
change, if you go that route, impacts a lot. It's, what are we doing that we don't know we're doing, you know? It's like if we outlawed automatic ATV use on a public easement, thinking, all right, that means the public can't go in there and just trash it without having permission, but somehow we now prevented permission being granted as well, so abutters can't even use it. Well, nobody intended to do that. That's the problem when you start making those kind of changes.
We have a couple of the butters that are, you know, they have health issues around our road. And they putter up and down the road on their ATVs and nobody complains, because, you know, the worst they leave is what we call turkey tracks from the tires. But, you know, they're not chewing it up. So they should be allowed to use it. I agree with you that there should be some way of specifying what the exceptions are. A landowner should be able to use it on his own land, certainly, but can he also use it on the rest of the road he lives on?
But who specifies? Council? The
Under,
abutters?
well, under Title 12, it is the municipal or county or unit of government
Right,
can designate a way and has authority.
That can't exclude anybody.
That's what I was saying. You're opening up Pandora's box.
Right.
Because you're saying, oh, like, that's the problem is you can't limit access. So you say, yeah, you're gonna use that as an ATV route, like, everybody's coming. Like, if they got a wheeler, they're gonna head to Roberta's house, even because your neighbors are riding it. So then you're like, oh boy.
yeah, I mean, we've had towns try to make access routes only open to town residents,
Yeah.
but there's no legal.
It's unconstitutional.
Right.
Yeah.
We understand. So. Is there, I know there's maybe one person disagreeing, but is there general agreement that it's a good idea to retain a public easement after discontinuance or abandonment of a town way?
I think some access needs to be kept, but whether it should be a public easement or not. That's where I like the idea of giving the landowners the option of agreeing to make it a private easement in common. That idea actually, I wasn't the first one who came up with it. I didn't know somebody else had come up with it first. But in the town of I'm trying to think when it is, Newburgh, town of Newburgh. There were some landowners who had a discontinued road that crossed their property and went into the next town. And they were having problems with people from the next town coming through. And they went to the county and said, can you just continue this road? We're the only ones that need it for access. They can, people in the other town can access from their end, but we're the only ones who need it. Can we just continue it? And the county said, we can't discontinue that road because under the county discontinuance laws, there were no easements. And it was going to landlock the people on their side of the town line. And they said, but if you landowners will agree to grant each other private easements, sure, then we'll discontinue it. And that's what they did, and it worked, and it's still working. And this was years ago. This was while counties still had the authority to discontinue their roads in towns. So it was before July of 1976.
So something needs to be kept, but in your mind, it could be either the public easement that we know and love now, or
Or no one
private. Or a private easement in common.
I think it's known. Yeah.
Yeah.
So, yeah, I mean, does a private easement in common though get to all the same?
Well, the idea is the public wouldn't have rights, but all of the landowners would have rights.
And that's what, like, I look at the public easement as like, especially from our perspective, like, hey, listen, like it's access to hunting, fishing, trapping, everything like that. I mean, the 40 acres may be posted past the public easement, but there may be 200 that's connected to it that somebody can get into that. So that's where the public easement from our eyes is important. for sure.
Yeah, because a private easement wouldn't provide that, right?
I would agree, if you make it private, you've eliminated any chance of having trail or anything going forward.
Well, yes and no. I'd say there are two solutions to this. One is, okay, if the public wants to keep a public easement for the recreational use, they should provide enough maintenance to support whatever use they're keeping it for. If they just want it as a snowmobile trail, then there's not gonna be a whole lot of maintenance, because it's not gonna disturb the soil. If they want it as an ATV trail, they're gonna have to put something in.
But I
it.
guess who does that decision is made by the town, so who does that fall upon? Because then you're saying, like, I mean, if it's an ATV trail, it's a snowmobile trail, the guy with the 4x4 pickup truck comes through that lives in Fayette. Where's his money come from? It's not a road tax, like, I mean, it's not his gas tax that goes to the public easement. So like you're gonna hit the snowmobile clubs and the ATV clubs for the money that the damage is caused by something else.
But is he allowed to? Or is it specified that it will be just?
Well, it says right now in a
for
public
just
easement that a 4x4 vehicle, motor vehicle can operate there.
Yeah, on the public easement as it is now, pretty much anything
Right.
can operate there.
Except the
Log
ATVs,
trucks
snowmobile.
Well, except that, well, going forward,
Right.
so only on the ones that have been
Correct.
discontinued since that law went into effect, all the ones
Right.
historically.
Yeah.
So every road that's gonna be discontinued in the future or considered for that. Every one of these is different situation. There's a lot of them that dead ends because they get down to maybe nothing or a house. Others might be shortcuts between two public roads and there's no one there, but. Every one of these is different, and some of them you're gonna landlock. Possibly someone, others, there is no possibility of landlocking anybody.
Mhm.
And others, everything is different here, so why not let the abutters, the property owners, the landowners are on that road. Decide what to do. Because you're not necessarily landlocking someone, maybe you are, but. If that's the case, if it was public land or something out there. Then that should be addressed as, no, we can't shut this off. But if it's all private property, why not let the abutters?
The problem is that 95% of the state of Maine is privately owned. So you're not talking like in all those recreational activities occur on 95% private land. Which is like, it's not Bureau of Public Lands, it's not We don't own a lot of government land here in the state of Maine. It's very highly sought after because it's owned by you and I. So without that ability to get out there, it's hard to recreate sometimes, like if you're limiting access. Like we're dealing with it right now with boat moorings. Like there's a boat mooring, well, we probably saw it in the paper today, Winthrop Town. So they made a mooring ordinance that was limiting the access to the lake. So they're saying that the moorings there in town could not be used. They could only have a mooring if you were a property owner. Well, they can't do that. Like you have to provide 10% of the mooring. You have to provide a mooring location. And you have to provide a spot for those people who don't live on the body of water to have a mooring. And I think that somewhat you're limiting access there if you're saying that there's like. Well, I mean, you are
Problem has been
landlocked.
too that most coastal communities have mooring plans.
Correct. That's
Most
what,
inland lakes don't, and.
Correct.
And more people from away are just throwing moorings in,
Yes.
but that,
it was meant for
that's
coastal.
beyond our
Yes,
jurisdiction.
yes.
But it is.
But it is limiting.
Hey, I'm on if you'd like to join in.
If you have 6 people who live on a road and you have a private easement. They have a public. So all 6 landowners, we'll call them landowners at this point. Have access, but nobody else does. Or do
That's
you
right.
Unless they give permission.
Yes,
get permission from who?
One of the landowners.
One or all of them?
Well, as far as you want to go down the road, I guess you'd need to have it, right?
Could be gated.
It could, and you could get to the situation where, 4 of them decide to be nice folks and 2 of them who live near the front of the road decide to be jerks and they do put the gate up.
Which we've seen.
Yeah, we've got reports about it here and we've heard about it.
And as I understand it, the courts have ruled against those gates. So when you go forward with a private easement, aren't you just making more court cases?
There's the potential that the people who live down the road have to file a lawsuit against the people who are blocking their access. Is creating a potential for that. That's why you'd like to see a friendly situation where the private easements are worked out, and there's a road association. And that's what the discontinuance law encourages for that first year. The idea being, come up with private agreements. If you don't want public easement, we'll, work it out. But you don't know that those private arrangements are always going to work out. Someone may want to try to block someone else's access and it all goes downhill fast.
I think where a lot of the problem with gates has come up is where there is no either public easement or private easement. There was a road that was discontinued before public easements were kept. And one person buys land on both sides of the road and says, okay, I own some center line from both sides, I'm blocking it up. In cases where this new law is applying, where the landowners are given a year in which to work out easements. A couple of things I see that could be improved for that. One is to make it clear that if they can't all agree, if some of them can agree, particularly the ones farthest in, because usually it's the ones near the beginning of the road who want to block it and keep everybody else out. If you say, okay, the ones farthest in are going to make it a private easement for their few pieces of property, but the beginning of the road is going to remain a public easement so that nobody can block them from getting in. Then hopefully after a few years, they're going to look at the road and say, no, that part beyond us is in pretty good shape because only the landowners are using it and they're maintaining it. The part that I'm on is still a public easement, and nobody's maintaining it. So maybe they'll join in. And I think this is another thing that could be fixed in the law, is to say that it doesn't have to be done in that first year. Give them a year at least in which to work it out. If they haven't worked it out by the end of that year, if 5 years down the road, they say, on second thought, this public easement isn't such a great idea because the public is ruining our road. Let's look at that again. They should be able to come back and discontinue the public easement. And this is where the law as it stands is kind of ambiguous, because the title on it, it says that it's the process for discontinuing townways and public easements, which implies that you can use it to discontinue a public easement. But then you go down into the process and it doesn't really mention public easements again. It sounds like it's just for discontinuing townways.
That sounds like we're looking at A4, the statutory process for abandonment or discontinuance of a road. And that was an interesting thought that we'll call the first few 100 feet maybe a public easement and see how that all works temporarily. But that's gonna make it really tough for the realtor, for the attorney doing title, for anybody looking at this to understand what's going on, because we know that if it's a road that was discontinued before 1965, there wasn't the automatic public easement. But they could retain a public easement. Back then, it was called a private way subject to gates and bars. So you have to understand all of that. You have to understand that roads leading county to county are discontinued by county commissioners until it became townways in 1977. You have to understand that the law changed at 65 for the automatic retention of the public easement. And then the law has been changing over the last 6 or 7 years, so that when a discontinuance occurs, the process all changes. If you keep changing the process, you're gonna make it harder and harder for people to analyze this and look at it and be able to give you a definitive answer of what kind of road do I live on. So that when you're asking a realtor or an attorney or a seller of real estate to check that box, to the status of the road, you're gonna get garbage or unknown.
That's why the new law says that when you discontinue a road, you have to file it with the DOT and the Registry of Deeds. So on the recent discontinuances, anybody should be able to go to the Registry of Deeds or the DOT and say, what is the status of this road? It should be all in print. Technically, there was a law on the, was still on the books, Title 23, Section 3024. That says that when a road is discontinued, it should be registered with the Registry of Deeds. But because it comes before 3026, who looks at the discontinuance process and then flips backwards a few laws to see if there's something further about it? No, you continue on from there. So very few towns even knew that that law existed. And the language of it is so garbled that it sounds like you could file with the Registry of Deeds and not notify anybody on the road and it would be legal. Or you could notify everybody on the road except one, and it would be legal except everybody, be legal against everybody except that one. How do you discontinue a road for everybody except one person? You can't do that. So the language was so confusing. I think that's part of the reason that we don't have these filings since 1959, I think, that they're supposed to be filed. If people had done that, or if that law had been clearer and in a place where towns could find it, then we might have a record for all the roads discontinued since 1959. But we don't.
With that, would it make sense to, we've been meeting since 1 o'clock, take maybe 5 to 10 minutes just to clear our heads out and then come back and see if we could wrap things up in terms of consensus for a report? Does that make sense? We can maybe walk away from.
Vivian must be, everybody must be working remotely, huh? Oh my God. Yeah.
We did.
Talking about how there's no like.
Yeah.
All right, are we back?
Sort of.
Okay, so when we started this out, we were trying to answer some of the questions that the legislature set out for us to address. We're supposed to be considering property owner liability. I think we've talked about that, particularly with regard to property owners along public easements and how we might do something to protect them from liability or minimize their liability if they go out and fix it and the town doesn't. Public easement retention, I think there's a sort of a division, well, there is a division of opinion with, is it fair? How many people support the retention of the automatic retention of a public easement when a road is abandoned or discontinued? So straw vote.
That's an odd question.
Yeah.
Well, right now, that's what the law does. Do you support the continuation of that? And
I support making sure that there is access, that nobody becomes landlocked,
okay,
but how that's done is another question.
how many people support that idea? Keep supporting retention of some access so that no one's landlocked.
Yes.
It's much better than. It's a good-
We have unanimity.
Mhm.
You better
Write that down.
document it.
This is probably not gonna happen again.
And so as to the nature of that access, is that where the issue is, whether it's a public easement or a limited access road? I think is the other idea.
I gotta ask one quick question.
Go ahead.
There is a procedure to discontinue a road, but is there a procedure to just abandon it?
No, because abandonment happens. As one municipal attorney once described it. Abandonment happens because a municipality doesn't do what it's supposed to do long enough that it doesn't have to do it anymore. What it did for 30 years of non-maintenance is a presumption. If the town doesn't spend money to maintain our town way for 30 years or more, then it's presumed that it's no longer a town way.
Gee, you mean if I don't clean my room
So-
for 30 years, I don't have to anymore?
In that
And the
case,
owner's not gonna assert it.
yeah. So in that case, is it treated as discontinued?
It
or
has
is
the
it
same,
treated-
well, until recently, it's had the same effect as a discontinuance, which means if the parties onto the center line and there's a public easement that's retained.
So, but now it's not that way anymore?
Well, it's a little bit different now because the changes have been made in the last couple of sessions. And so now when you go to discontinue, there's that 1 year period for the parties to work it out before you propose discontinuance and in the event of an abandonment, the easement that's retained is a little bit different than it used to be. It's only for vehicles, motor vehicles, not ATVs,
Right.
not snowmobiles, and for pedestrians.
So, but when you do a discontinuance, it isn't necessarily that same
It's
limitation.
It's a public easement, but without that same express limitation, which is.
And so if you discontinue a road with a public easement, ATVs and snowmobiles can be used. But
Well,
if
at least-
it's abandoned
it's
currently, they can't.
It's at least not barred,
Right,
If you don't mind.
okay.
okay,
Whereas on the abandonment, they are barred.
because they're not a motor vehicle. they're
Future
not
forward abandonment.
Going forward,
Today, if one gets abandoned,
Yes.
right? And you look at the end of that 30 or more consecutive year period, and if it's happened, then that's when the abandonment occurs. That's when it's effective. At the end of that 30-year period.
There are two other things that come into this. One is that under the new abandonment law, 3028A, it says that the selectmen have the discretion of claiming common law abandonment, which leaves no easement. And it doesn't say that they can only do that if it won't landlock anybody. And that I think is a problem.
That's always been the common law, though, that if the town is stopped, if people stop using the way.
That's the key.
Right,
And
there's
in
a-
common law, it has to be no
Public use.
use. But the abandonment statute doesn't say that common law is through no use. It says that they can decide that they're going to claim common law abandonment.
Right, but then you look at common law abandonment and it says no
Okay, I
use.
think that maybe needs to be clarified.
But that's, Yeah, I mean, you can abandon a road at common law, which means judge-made law from case to case. That's been there in the books for years. And so if the public stops using a road as a road,
It's funny you say that, because I was just thinking, I go, there's a lot of these roads that if the ATVs and snowmobile clubs didn't use them. There wouldn't be no way that anybody could get through with a 4x4 pickup or like any type of motor vehicle.
but if the public stops using a road, and it used to be easier before ATVs and
Right.
snowmobiles and everything else to say, oh, no one's used that for years. It's a track, everything's grown over. You
Yeah.
can see there's, bushes and trees where there used to be a road.
Trees growing up through it.
Right, exactly. And that's 20 consecutive years or more at common law. It's no longer a public way. And so at that point, there is no public easement, there's nothing. And the idea was no one's been using it, so why should we be spending money? And what the presumption of abandonment statute was a sort of a test. If we haven't spent money to maintain it for at least 30 consecutive years, then it's probably abandoned. So that's the presumption of abandonment. It's sort of a marker so you don't have to go to court on each one of these common law.
So, but who hasn't spent money? I mean, if you get a snowmobile club out there spending
Town.
money, that's using state
Municipality,
money.
municipality.
So just, all right.
Has a municipality spent money to fix the road, to maintain the road?
And the other thing I was going to say is that on discontinuance, where it retains a public easement, then the question is, which definition of public easement do you go by? Because if you go by the definition in section 3022, a public easement is for access by foot or motor vehicle. And that definition excludes the ATVs and snowmobiles.
And that's the definition in 3026A as it's been redone for abandonment.
Yeah, it's the same now, isn't it?
But it isn't the same definition for discontinuance.
So where does it say in the discontinuance, which definition they're using?
It doesn't, it
That's the
just says
problem.
public easement.
That's the problem.
It's too much fun, and that gets us. That gets us into 2A3, where you talk about statutory terminology related to abandoned or discontinued roads. And it seems like there are some issues there with regard to, public easements versus private ways versus private roads.
Mhm.
There's a lot of interplay there.
I do know that the Maine Alliance for Road Associations is working with Kepler and Vitale on a bill that would clarify the definitions of the terms private way and private road. It would say that a private road is a road that's privately owned, privately maintained, and over which the owner can restrict access. And a private way is an obsolete term and should be taken off the books and replaced by public easement.
We could suggest that there be clarification of terminology and just acknowledge that there are these issues.
There is
That's
another
a
bill.
fair statement.
Yeah, fair statement.
Okay. Glad we can reach some consensus on. One article we're asked to, one area we're asked to think about and to come back with our consideration is the statutory process for the abandonment or discontinuation of a road, including barriers to determining the legal status of a road, like the legal status of a road. I don't know what we're supposed to do with that. We've talked about the process. We've talked about the fact that it's changed several times. Yeah, I think people have expressed that it's expensive to try to determine the legal status of the road. It's fact specific. It takes time and expensive litigation to do. There's been thought, I think, toward suggesting mediation might be possible. And although mediation is required in litigation, you file a lawsuit, and these days there's now mandatory mediation for any civil dispute. You got to file the complaint and act as though you're going to go to court to litigate with all the expense that entails to get to that. Is there some other way to mediate these disputes? Is that something that I'm hearing people suggest? Shouldn't get to court if we can avoid it.
Jim, I don't know much about the court system, but does what you just said, does that apply mediation to small claims court, district court cases, superior
Superior
court?
court cases.
Just superior court.
Generally, yeah. We're cases that are big enough to be brought in superior court, if there's civil litigation, there's mandatory mediation at this point.
is that for all Superior Court cases? So it's my understanding was it only applies to certain categories of cases.
Well, okay, most civil litigation will wind up that way. If it's what we call a Rule 80B dispute, where it's a planning board or a board of appeals appeal, it's not going to go there because that's going to have its own process on the record, and it is what it is. But if you're talking about a new case where the idea is to have an opportunity to meet mediation, your construction dispute on your real estate purchase, general civil cases that we see. And so that's there, but you have to be in the court process, which opens you up for all the time, expense, risk of litigation. I was hearing something a little different, that is there some way to have a mediation specifically for road cases? Is that something that you'd like to suggest?
I would like to suggest that, some sort of streamlined.
Yeah.
Alternate dispute resolution specifically for these kinds of cases.
So again, not knowing much about the court system, that was one of my three things was. Why Superior Court, which I assume is for the big cases that. There's a lot of big decisions made in Superior Court. Why can't this be in a lower court decision where it's a lot cheaper and quicker?
Yeah, and the answer is that this is not, district court is for the smaller criminal matters, well, for criminal matters, and it's also for smaller disputes, small claims. I think small claims limit is $6,000. And but it's low, it's a nominal amount, so this would not go to small claims court.
So you're saying road issues like this,
They always go to
whether
Superior
they're
Court.
simple or complicated, can't go to small claims or district?
They're declaratory judgment actions, and those have original jurisdiction in front of the Superior Court.
Superior Court is the right place for this type
Yeah.
of stuff.
Okay.
District Court is more like, I consider like family matters.
Well, family law and you know, the typical criminal.
Yeah.
Breaking and entering
Okay.
things and the smaller class crimes.
But like this fits in with like code enforcement issues and things like that. The tax abatements, that all gets appealed to Superior Court, so I think it makes sense to go there.
Well, because you're asking the court to declare the rights and obligations of the parties. Declaratory judgment action, and those are always brought in the Superior Court. So that's how you wind up there. It's a more serious situation, and you could wind up, but you will wind up with a bench trial, and it'll take a couple of days to get through one of these, which is why it's so expensive.
My question is whether we can plug into some programs that already exist. There's the family and community mediation service, which I think they charge $175 per person for the whole process, which is certainly a lot cheaper than $300 and some odd dollars per hour for an attorney. And then there's the cooperative extensions agricultural mediation, which they do mediation for free if there is either forest land or farmland in production involved. A few years ago, they changed the limited liability to where it used to say, or not limited liability, the one where it talks about if someone damages farmland or cropland in production, that it's a Class E crime. A few years ago, they changed that to say, or a public easement. So if they can lump public easements in with forest land and farmland in production in that statute, can we somehow get that in onto the agricultural mediation program? Because they could address matters that had to do with public easements.
So basically look at some existing mediation programs to see if that could be the place to bring alternative dispute resolution.
And that might involve seeing if we can get some extra funding for them to address those cases.
So this will be one of our list of funding requests, that in addition to our ongoing work, so obviously this will have a big ticket to it.
Now, the Superior Court has a business docket. I don't know that they want a road docket, but but there we go. They have one, you know, just working in business cases. And So when we drop down for matters relating to abandoned and discontinued roads, other than these 4 topics that we've just been talking about, we're supposed to prioritize matters for consideration by the commission by determining which matters have significant negative impact on owners of property that abut an abandoned or discontinued road, owners of property accessible only by traveling over one, recreational users, members of the public, local government, state government. That's the prioritization, I guess, of a piece of what we were talking about, and all of you took a look at and considered. When you talk about those issues and ones that we maybe haven't bumped into dealing with 1 through 4, what comes to the top? What's the major issue we see?
Loss of access, whether due to discontinuance without an easement or due to discontinuance with an easement that isn't being maintained. They're not publicly maintained.
What do we think about that? From the property owner or the property owner access issue, is that primary?
I definitely think the liability side of it would be just. For the situations we've had, the guy that's trying to do the right thing, but still held liable is. That's a make it or break it going ahead if they get dragged into that.
Yeah, because as it stands right now, if you're a private landowner on a road closed for winter. And you go out and plow it to get into your camp or whatever, and there's an accident, you're automatically at fault because the law says you don't have the right to be doing that.
Closed for winter maintenance, I don't think so, right?
Yeah, I think that's separate, but certainly if it were. You have to be, if it were a town way. You can't be doing work on it. I think that's the issue. You shouldn't be working on a town way. And then the question is, if it's closed for winter maintenance, are you allowed to do anything on it?
The legal opinion we've gotten from MMA would say, yes, you can allow.
To get to your own
to get to your own property, you can maintain.
And you're not liable.
I guess it's, I don't.
Well, we'll see what happens. when
Town's
your
not
plow
liable
hits
for
something.
allowing.
The
you to
town
break
is
it.
definitely not liable, but.
Right,
So then that begs the question, who is?
Well.
Why do we live in a country where somebody's gotta be liable?
Right, well, and you're only liable if you get sued,
You're making your own decisions.
you know, and
Like that.
maybe it's never been tested.
Personal responsibility.
But what he's saying is, he has a camp that he plows the road to, it's a town way, and somebody else goes on that road, has an accident. And that road was technically closed by the municipality for winter maintenance. But now all of a sudden it's open, can the person sue the person who opened it up? You know, he didn't sand it and it was slippery because I stuck that night, but the town would never have opened it to begin with.
Yeah, and the person plowing by closed signs in that case.
yeah, if I were the plow driver, I would have gotten a signed release from you, as the property owner before going on that road.
Took a wrong turn, GPS said he could go down that road, I mean, there's so many
I know.
possibilities.
yeah.
I think that goes to John's point, the liability issue's got to be addressed here, people gotta make their own.
But people sometimes can't, and like, we joke about the GPS thing, but I have seen
Oh,
tractor
yeah.
trailers drive by, road closed. Drive by it, because this told them to could.
We see it all the time in snowmobile and ATV trails, they're literally stuck with
Yeah.
18 wheelers.
The first year of COVID,
Poland's, get out and get stuck on snowmobile trail. It happens, I mean, I think of at least a dozen cases with Poland spring trucks.
I mentioned
They're following their GPS unit.
the tumble down road, Weld Road, like when the pandemic hit, we had such an influx of people in the outdoors. We were going up there in the middle of the winter, which is winter maintenance. And we had 8 vehicles stuck and we're trying to get to the mountain to get the people off the mountain that are stuck up there. And we're driving by them and we're like, we'll get a tow truck to you eventually, but you're gonna have to start walking back 7 miles. And they were just clueless. They're just driving up the road that's 2 feet of snow.
Google Maps said I could.
Yeah, Google Maps.
Somebody sunk through.
Oh, they were just bare with like
Hmm.
Subaru, like little,
Because they could go a while, they went a while, right?
because they could ride on the snowmobile trail.
Right.
They could ride on.
Right, got it.
Just like, oh my God.
And we had somebody who was commenting on the screen there that liability isn't the main issue, access is.
Sounds like they're both issues.
I think liability would cure a lot of the accidents.
Yeah, that's what I'm with you. I think access is an issue. I mean, there's a variety of reasons, but the concern about liability prevents access. I mean, we see private landowners closing land all the time because they're scared of liability.
You're talking about access for the snowmobiles, though.
Well, no, I'm talking
Access for the
about
landowner.
everything, hunting,
Oh, you're talking that. yeah.
vehicles.
We're talking about landowner access. If you can't get to your property,
Right,
Yeah, and landowner access and then recreational access, and there really are.
I'll raise the recreational access flag.
Right.
That is a concern. The Snowmobile Association in the state of Maine did a economic impact study. That just snowmobiling alone in 19 brought in 606 million. And ATV is supposed to be north of that now. So if that money doesn't come in, your taxes will be quite a bit higher if the access goes away.
Can you say that again? 606 billion?
606 million is what was figured out in 19
Thought I heard
by
that.
forced.
and ATV is supposed to be 746.
For sales tax alone, or?
No, that's
Economic
economic.
impact.
So that's, all the multipliers and the jobs.
I'm going back to your comment, Roberta, about like access by the people, like by the people that own the land down there. Like, I mean, I'm just trying to think like, why don't they have access all the time? Like, I mean, other, like, they bought the place, they lived there. Like, are you talking winter access? Like,
we're talking about if you buy a piece of land and you think, oh, it's a discontinued road, I'm gonna go to that, I'll build my own access. You build your own access, and the logger who owns the next piece of property says, well, look, I can get to my land now. He uses it, tears it up, leaves you with no access. You
which
rebuild
was,
it,
right,
a mud runner comes in at the height of mud season, drives up and down the same 2 ruts on a hill. The water runs down those ruts, washes out the culvert
which I
at the end
think
of the road.
goes
you
back
have
to,
no
well,
access.
and the reason why I asked that is because it goes back to our comment about like people that are using it, having to reimburse them for leaving it the way it is. Like with the logging permits and stuff. It's not like a limited access, it's the maintenance of the road, the maintaining the road so it's travel, you can travel it. Is what the access issue is for the landowner.
There are 2 sides to that. There's the problem that I just said with access when it's a public easement, other people can tear it up. And there's the other problem of roads that were discontinued years ago before they kept public easements. And now somebody buys property on both sides of the road and shuts off the
Right,
access.
right.
So it seems like there are really 3 almost co-equal issues in terms of priority: access, liability, and then maintenance, prevention of damage to the roads. I think we probably heard all of those comments in equal amounts from people,
And they're all tied together.
right?
Yeah, they definitely are.
Yeah, and I think, Chris, your question was really helpful to ask you to say it again, Roberta, because a number of times you said this. Sometimes the words sort of lose their meaning.
Well, I
unless
also
You go
like-
and paint the picture.
Because the way you just, like with the landowner that owns both sides of the road and closes off with, I think that's almost sometimes a separate issue when it comes down to a like public way or anything like that. I mean, because, I mean. A lot of times those ones that I've seen are a private road. They're not even, like, there's not even a question. And they're gating it across. They're doing it because they can. But they put it in, they come to us to see if they can have the access. I don't know if that's,
Yeah, but the point is, there are, some of these roads are doing the same. thing.
right. Yeah, I'm not saying,
And that's what's really crazy, because if you live beyond it and all of a sudden now you are landlocked at that
Mhm.
point.
right,
Now,
Which I didn't think
what
they
often
could.
happened on these old roads, the ones that were discontinued before 1965. In a lot of cases, the landowners kept on using the road, and they've been using it for over 20 years, often over 30 years, 40 years. And legally, they could claim that they have an easement by prescription, because they have used the road. well, it isn't a road anymore. It's like when the road was discontinued without easement, it became a patchwork of little pieces of private property. And so if somebody continues to use that and they're crossing all those pieces of private property without the permission of the landowners, but with their acquiescence for 20 years or more,
They
open,
retain that.
unobstructed, open and notorious so that anyone can see it, they're using it and isn't objecting, then technically they should be able to claim an easement by prescription. But in order to confirm that, you have to go to court.
And somebody could say,
So-
you don't have an easement by prescription.
Right. So somebody new moves in, buys property on both sides of the road and closes it. Now what's that person have to do? Now
So
they. have
had
to
they
go to
gone in
court.
with the prior landowner into court and claimed that easement by prescription before the new
Well-
owner came in?
What'll typically happen is, somebody may have been using it for 30 years,
Mhm.
and then the COVID refugee from New Jersey comes in and buys a lot at the beginning, and it buys land on both sides of the road, puts up the gates and bars, and the person who's been there for 30 years, has access, and then has to sue those people, and $75,000, and 2 years later, they'll get a decision from the state Supreme Court that, yes, they have a right to take those bars down, they do have that, but you've got to go through all the hoops to get there. It doesn't.
So is there a
Doesn't
way,
necessarily seem right, does it?
is there a way to make that process easier?
Well, that's maybe what your ADR, an alternative dispute resolution process might.
What about appeal to the county commissioners?
The people's.
The all new county commissioner?
The people's court.
All right, so, I'm trying to get some direction from you, but I think we've got it in terms of looking at those three issues together. I'm gonna throw something out there, because I've heard it from different people in different ways. And that is, imagine that you're going to buy that property on a road. You don't know, is it a town way? It says town way in the deed, but as we all know, that doesn't mean anything. Because it's what, is the town actually maintaining it? Has it been discontinued in the interim? Have people stopped living there for over, and using it for over 20 to 30 years, so that it doesn't really matter what it says on my deed? All those things could have happened. So right now, there's a disclosure on the Realtor. And the Realtor might look at DOT's site that Pete has told us about. But all that says is whether the town's currently maintaining the road. It doesn't say what the road status is. There's been talk about some idea of requiring road inventorying. Certainly, it's been recommended. It was recommended by MMA Legal Services and has been for, gosh, first Joe Watson was writing those articles, and then I was.
I don't know if
So-
I can see the first one,
Yeah.
1990.
Yep, so it goes back a ways. It's been recommended. There's a cost to doing it, and as you can tell, even at the municipal level, with all the records they have, there'll still be question marks. I mean, if you were to try to do this, there's still going to be instances where you don't really know. So how do you do that? Whose obligation is it to prepare a road inventory? Who's going, if that's a good idea, who's going to pay? What do we do in those who knows instances?
I think it needs to be done in steps, not try to do it all at once. Start by putting on a map that everybody can see the roads you know that the town does maintain. And then bit by bit, start figuring out the others. Start maybe with private roads, which a lot of that information you can get from the E911. And then go through town records, find out where you can pin down that a road was voted to be discontinued. Go through the DOT map viewer and see where there's a county road that was discontinued. And you're gonna at least get a lot of them. And granted, there are some that are gonna be real puzzles where, okay, we have a vote to discontinue a road from Joe Smith's barn to the state aid road. Where's that? Yeah, you're gonna have some of those that are gonna take some real effort to find out where they are. But if you can at least get some of them, that's gonna be a help.
So who's going to do that?
I mean,
Well, I know you've been
So
doing it.
So there's two things there, I think, from an MMA's perspective as well, is that the inventory alone doesn't determine the status.
Right.
It just tells you what's being maintained, but it doesn't even tell you on those maintained roads, the status. So they're two different things, and there still are due process rights. So if the town says, that's our road, there are still due process rights for the folks that live on that road who don't think it is. So that is gonna come into play with that process. The reason that that statute was changed to May was because the legislature did not want to fund it. And by the Constitution is required to do so when they expand municipal duties. They have to provide that or override that.
100% or 50,
90.
90?
And we're probably looking at what that inevitable price tag is on the number of roads and the legal fees to pay Jim to sort out their status. And decided, yeah, we're not gonna do that, it's not.
Do you have a recommendation on how you could get this process started from your angle?
But is the process looking to identify inventory on what is maintained or what the legal status of every road, public and private is?
Well, they're two different things.
What are we asking for here? Because one's
Start-
pretty easy
start
to
with
do
what
and the other
you
one's
know.
not easy.
Start with what you do know and then chip away at what you don't know.
Well, his website's already given us the
So,
easy one.
Yeah, we review so many of these things and if you look at map viewer, yes, it's all about maintenance. And I will tell you that 95% of it is correct. There's not a lot of tweaking there to be made, but every town I go into to do a review, I always come out of it with some little changes that amount to not much. That's why it's 95% correct. From a maintenance perspective, and I always tell them when I sit down with them, I say, look, I'm here to talk about what you maintain, period.
Right.
I'm assuming, and you're assuming here that what you're maintaining is truly indeed a legal town way, but that's not what I'm here to talk about. I want to know what you maintain. What do you guys plow? What do you grade? What do you pay?
Right, and the downside of relying on that is that it might be a public easement
Correct.
that the town's not obligated to maintain. So in 2023, they may be maintaining it, but next year, the town meeting may decide it's too much money. We're not gonna spend that anymore on that road for the.
That's true, but
That
if you
doesn't happen a
use,
whole lot.
if you're selling, if you're a realtor. In the point of sale, you look at what's currently going on. I mean, you can't predict what's going to happen 20 years from now. That's not
true.
certainly a responsibility, but at least requiring them to look at that now. That'd be an improvement over where we've been.
So if we tie the realtor disclosure to DOT's website on town maintained roads.
Right, because the simple reality is you're gonna have a bunch of other roads out there that, well, what is the status? Bottom line is we don't know. So if it's not on, if this piece of land you're trying to buy is not on a currently maintained road. Think carefully before you buy it, right?
Right.
Well, remember, as I went through on the map viewer thing, remember the colors. The
Right.
blue were the town maintained roads. And if they weren't colored, that data set is coming from the 911 office. It's not just DOT, it's DOT and 911, and where anybody lives. It's got a street name. And so it's public or private. So if it's shaded in. It's not town maintained. We can say that for sure.
Right.
What its legal status is who knows? And 911 doesn't care what the legal status is. They want to know where people live.
Right, and so the idea there is that if you want to know the legal status, you have to do your due diligence, but at least is it town maintained? And as of right now, DOT says yes.
And, all these reviews that I've done, there's not a lot of changes in roads. Roads have been in place for years and years and years and years and years. If I pull out an inventory, if I go pull something out. And I go in and do an inventory with a town and it's been 15 years. I'm not coming out of there with a whole lot of change. It's little stuff. Well, yeah, we go to the barn, we don't, it's 100 feet here, it's 100 feet there, it's not much, it's not significant.
What about new subdivisions? Town adopts. a new
Well,
road.
the only reason those would be missing, Ryan, is if the addressing officer didn't do their job and submit it into the PUC as a subdivision. And they're supposed to put, is it publicly maintained or privately maintained? You check one box or the other. If it's anything public, PUC automatically send it to me to DOT. And what that means on map viewer, it'll go from a shaded road to a blue road. But that doesn't happen a whole lot. So that's why if anybody uses map viewer to look at who maintains it. For realtor purposes. You're probably gonna have 95% chance that it's gonna be correct.
So we need to give the realtors the tools that they can use. They need to know that they can go to that
Yes, you
site. and
suggested
they-
that.
That's what I suggested as the first thing in mind was. Let's do some training with the Maine Realtors Association or whatever it's called.
Well, the other thing is, I haven't looked at one of these disclosures, but. Do we have the options there for them to disclose it's on a maintained road versus an unmaintained road?
What we're,
Yes,
I haven't looked at the disclosure in a while. It isn't quite so clean, but we can make sure that, well, we can recommend that the law be consistent with what's out there for data for people to look at.
Is that- I mean, if that just means having another box there that,
Or
go one
modify
way.
the language of the box to be consistent with what DOT has available.
what it says, I believe, is that if the road is not maintained by the public, they must disclose who does maintain it if known.
Right, I got it right here. It says access to the property. Information describing the means of accessing the property by one, a public way as defined in another section. Or B, any means other than a public way, in which case the seller shall disclose information about who is responsible for maintenance of the means of access, including any responsible road association. And the key sentence, phrase, if known by the seller.
And where this has worked very well is because I'm also involved with the Maine Lands for Road Associations. And as I said, my daughter is on a private road that's maintained by a road association. We're finding that when a piece of property on that road is sold, the realtor will get in touch with the road association and say, who is the contact person? What are your bylaws? What are your annual dues? And they will give that information to the buyer. So for that piece of it, that has worked very well. When it comes to the roads that are unknown or that don't have a road association, or where it's an informal road association, in other words, David Mander is taking care of the road out of the good grace of his own heart and is tired of doing it. That doesn't get put on the form.
So maybe the more relevant question is the road publicly maintained or not? And
Or does it show up on a DOT?
you would, and to determine that, you'd look at MDOT's map viewer.
And the other thing I would add to that is, make sure that if it's one of those we don't know, or it's privately maintained, but we don't know by who, or, you know, it's a public easement. I think the buyer should be given some information as to what that needs. For example, going back to, what Mark Robinson was saying, you know, what if the Manders had known when they bought their property? Well, we knew it was discontinued, closed, private way, subject to gates and bars. What we didn't know was what that meant. Private way, that sounds like it's private, doesn't it?
So if
Yeah.
the box is unknown, then they get a copy of Maine Municipal Association's Municipal Roads Manual.
I was thinking, I mean,
How long from when David bought the property to when problems started coming to the surface? Like, it couldn't have been instant, right?
He bought it in 1971, and I think by 1979, he already had a lawsuit going against the lodger that would come in and just
Started
absolutely wipe the road out.
I guess in reference to that, like you could, like if we could get the statutory terminology like straightened out, so it was like a little bit better, you could refer them to that.
Mhm.
Like if it's not publicly maintained,
Right,
and refer them to the language there so that they actually have a clear understanding of what that road actually means.
Right.
Because then they'll probably start running the other direction and leave.
Mhm.
But I mean, like, there must have been people starting to use that road, like, I'm assuming if it was the private way is what is the problem, right?
It was a public easement, but
Public easement.
didn't say so.
Right, so there must, at some point, you must have started seeing vehicle traffic going by.
Come to think of it, the terminology didn't change until 1976. So up until 1976, it was still called a private way.
Nobody else was using it.
There were other people beginning to use it,
Mhm.
but it wasn't a real problem until that first order came in.
Yeah. Cause it increased the accessibility.
Right,
Mhm.
yeah, it's like I joke that Main Roadway's motto is build a better public easement and the world will beat the pathway to your door. As soon as you make it passable, the public says, oh, look, we can use this road now, and they start using
That,
it.
we should get that on a t-shirt. We could get our $500 for the website.
Bingo.
But I can sell it to most of the roadway people.
All coffee cups with that on.
So I think that gives us some directions to put together a draft report. Anyone have any additional comments or thoughts? Anyone haven't said anything, like to jump in and
I probably thinking as soon as I get home.
send me an email?
I got 4 hours to think of it before I'm home, so.
Just don't read while you're driving,
No,
okay?
I have a podcast.
So,
Okay.
so if it hits the main DOT website, that ought to eliminate 90 to 95% of the issues, right? We're just dealing with 5% of the issues. Is that the way it is?
Going forward.
Correct.
For
I'm
people,
just
that's
yes.
right, for people buying property, yes, that should, it should limit the amount of issues. Those roads where people aren't sure what
Yes.
happens because it's not publicly maintained. That is going to be up to due diligence and the statutes and maybe some lawsuits and maybe some mediation to figure out.
Or most of what we're dealing with in that category though.
Right,
That's
I
what
mean,
I'm
most
saying.
of the points
That's what-
she's got are not showing, they're on roads that. They have wrote, the website doesn't show they're being maintained.
Correct.
here's where I would suggest crowdsourcing. I have a couple of volunteers already who are starting to go into town reports at the state library and read through all the town reports, looking for all the discontinuances they can find. And some of those, as I said, are gonna be the ones where it's, the Joe Smith's barn and who knows where it is, but if they can at least document the ones that we can pinpoint where they are, then that can be added to the database. And the more people we can get doing that, I know if I advertised on main roadways, I'd probably get some more people who are willing to do it at least for their own town. I do know that Searsport has done their own survey. Somebody in Bodenham did his. There's somebody that's working out in Strong and Avon and Phillips and roads in that area. So the more we can get a database built of the ones we do know, the more that's going to help.
Along those lines, like where would a database be kept or who does hold that data? Like,
DOT,
well, I mean, it's not publicly, that's
Right.
like, it's not publicly maintained, so that's like.
They only care about public roads, really.
Right.
well, the Division of Rights of Way already
911.
has the county discontinuances, because years ago, Daniel Harriman and a couple of other people who worked there went to all the county records and copied out everything that had to do with roads. And so they've already got that in the Division of Rights of Way, but only for county roads. That doesn't go for town roads. So if we can do the same kind of thing for town roads, I don't know why they couldn't add that to their database.
Well, I think it might be that a road status inventory would be ideal for those instances where the roads are questionable. We don't know. But there are issues as to who's going to prepare the database, who's
Right.
going to maintain it,
Yeah.
who's going to pay for that.
right?
And until those are resolved, the commission's not ready to make any recommendations on
You
that.
can't even get money to maintain a website.
I know, they can't even give us $500.
Yeah,
Does that make sense? And
Yeah.
it's not perhaps the answer you'd like to hear with those people who are working in the registries now, but,
I'll have to get in touch with the guy in that part of the DOT and see what he thinks of it.
okay,
But
well, maybe he can
another
fund it.
piece, another piece of it is, well, what I'm saying is if you crowdsource it, it doesn't cost you anything.
but you gotta-
The other
There's
piece of
something
it,
that's got to live
It's gotta be
somewhere.
infrastructure.
Right,
It's all
it's gotta
done.
live somewhere.
That
That
That's
costs
why
a lot of money.
this commission has voices from so many different pieces of the conversation, and it doesn't really realistically live with any of our
Right.
Right.
full daytime jobs, so.
another piece of it is that I've been working for some time on updating my instructions on the Main Roadways website for how to research a road. And I'm pretty close to having it where I want it so that I'm gonna post it. And if we could refer people to that, say, you want to know what your road is, here's how you can search it down and find it out for yourself. And again, if we can get more people who are willing to do that research, then, you know, the more we get working on it, the cheaper it'll be per person.
Duly noted. So, I think we probably have enough direction to put together a draft report in 1 week. And get that out to everybody to take a look at. And your comments and responses will certainly be very valuable in helping us get a final product together. But the idea is that the next meeting, we would adopt a final report and then send that off to the legislature for February 1st. Is necessarily going to be skeletal.
Yeah.
That's the progress report.
It's right. It's a progress report. We just got started. And we thank you for all the money we didn't get for notice and, you know, we did our best.
How did they dare expect anything?
I don't know.
It's not uncommon though, right?
No,
I
it's
mean,
not.
keep these committees going and then you have such a short period of time. and-
Normally, they're just committees that meet between sessions. This one is an ongoing. So it's a little different.
They made it an ongoing one because they know that it's too big a problem. They've tried solving it between sessions before and they never got to it.
They just keep hitting speed bumps. So as far as forming subcommittees, probably premature until we get some direction from the legislature as to where they want to go and how. Other business and announcements for today?
So Jim, our next meeting was in 2 weeks on the 25th, right?
Correct.
Do we need or want to set something for February?
Well, we're going to submit that report to the
Yeah.
legislature for February 1st.
Right?
I think we'll probably have earned a little bit of a break.
Okay.
For a bit, unless others feel otherwise. But there may be some legislation that comes up this session that the legislature wants this commission to look at.
Yeah, they may want a presentation to state and local government, so there
All
could
those
be
things could
some
happen.
happenings before we necessarily need to convene.
Okay.
And we have a limited number of meetings per year anyway,
6.
6. So we'll have already used up 3 of our wishes.
But we can use subcommittees in between. can't
Oh,
we?
yeah, we can. And I think the question is, what do we want to do with subcommittees? And right now, I think we're set such a high level that we're not quite
I
there.
think we should do the report and get some direction back from the legislature.
See where they'd like us to go.
Jim, do you see this as a 1 to 2 page report or a 15?
Oh, not 15,
No,
not if I'm part of it. Just be, I think that,
well, there's going to be a
Yeah,
report and then there will be an addendum.
exactly, there could be, it'll be as
It'll
thick
be-
as the
the
addendum bar
addendum will be-
association.
The
Yeah,
agenda will be the phone book and the report will be brief.
yeah, exactly.
Will the.
Guess what, every time you mess
include
this up. you get another
Our
one.
minutes, our,
It can
Our
include
public
whatever we'd
comments.
like it to be, and if you,
I think they should see everything we've had to see.
I think that's right, I
No,
think
they're not
that.
gonna read it though.
it-
Well,
that's
I
for
don't
them.
think, I
At
don't
least
think
it's
we
off of
expect them
us.
to read it. I think we can say this is the most clear distillation of the
Sure.
very high, most high level
Sorry, which committee is it? I forgot.
state and local
State
government.
local.
they hear it's on this website. They
So,
can-
for example,
We don't have.
Yeah, there
Oh, you can't find.
there had been materials that Roberta had prepared, it was a briefing that I put together, there's the, your,
DOT tool.
the MDOT tool, and then there were the written comments that were submitted. So right there's a sizable amount, and their minutes, those are all
And the
materials
minutes.
that reflect what we've taken in for input and.
Now, our priorities compilation is 22 pages, 21 pages. I mean, that's, I don't know that we'll share that necessarily,
Right,
but
but it helps guide where we're going.
yeah, I think so.
Is there any reason why I should not post any of this stuff on the main roadways Facebook page?
Well.
These are
It's
all
all
public
public.
records.
It's all public. If you want to-
You're welcome to post. The only thing I'd ask is if they're only at the draft minute stage, we maybe hold off until we adopt the minutes, but once we've adopted them, I mean, they're still legal, but it's, you know, I just like to have the finished product out there, that's all. Does that make sense?
Yes.
All right. Anything else for
One
today?
more comment. There is, I know there are a few people who put comments in my.
The chat?
Yeah, the chat can't really be used unless it's a public hearing. I don't think we can use that specifically as the record, but I have been sort of following it and I don't see anything in the chat that wasn't echoed by someone in this room. I mean, if we want to people, the people who are listening out in, the virtual, hearing room want to send emails to the info at Maine Abandoned Roads Commission dot. That's not what it is. Hold on one second. If you want to email it formally, you can. But we can't really use the chat because it's not transparent to everyone.
One other minor thing, I've been referring to it as the Commission on Abandoned and Discontinued Roads. You've been referring to it as ADRC, and I was thinking add rock. Well, that's how you get out of the mud, is you add rock. to it.
Yeah. There's an O, but,
Well, it's the R and it's the O.
It's like a
Yeah.
license plate.
Yeah.
Figure it out.
so it's info.abandonedroadscommission@maine.gov.
He's calling me.
Is there a motion to adjourn?
Motion to adjourn.
Second, all in favor?
Yeah.
All right, we are not going to do a voice vote. Roll call on that. Thank you very much.
Thanks, everybody.
You.
All right.
I'll have to start and dodge next. How much snow up there? Very little.
Pretty good. Very much.
Yeah, they're gonna put up in the Allegash, right?
So one of my guys rode 70 miles today, been texting pictures.
Mud.
I've been trying to figure out how to give him the middle finger.
I talked to a guy, at
Try to get-
Hopefully it'll stay full. And I go, you did what? And he goes, oh, the snow is covered in mud.
Great.
Yeah.
Oh.
I'm like,
Oh, man.